I got stuck over there.
Down. You can't do that. No good. Good. Mm-hmm. Right. Yeah. I know. I never do.
All right. Ms. Wood, are you ready for Mr. Mosley to come on out?
Yes.
Anything we need to take up before then?
I don't believe so.
All right. Mr. Abadi, anything else? All right. Can we bring Mr. Mosley out, please?
Hello. There you go. What's the question? Good question. Good question.
All right, let's get started. It is a little after 9 on the 26th of June. We're back on the record in State versus Mosley. Mr. Mosley is in court with his lawyers. We have a prosecutor here, and we are going to have our charge conference and then take up anything else that the lawyers need to discuss before we bring the jurors back out for the rest of the state's case. I will share my screen, which will have on it the draft jury charge. There it is. And what I'm going to do is just scroll down to areas where I have questions. If I skip over something, about which either side has a question, let me know, and we'll go back to that. So first, on the top of page 3, the paragraph about evidence. Evidence consists of testimony and exhibits and maybe stipulations. How are we doing with a stipulation or stipulations concerning Mr. Mosley's convicted felon status?
We had drafted one up, Judge. I think Ms. Primovic had shared it with the state, so that's as far as we had gotten.
Okay, we're talking about the stipulation. You drafted something, Ms. Primovic, and sent it across. Have you heard back? Okay,
But I'm sure we will any minute.
okay.
The third one can be cut out. I tried to print it, but the network, as we know, has been down. I tried to print it yesterday.
Okay,
But,
we could also get it up on a screen if someone wants to email it to me.
okay, I'll email that. Yeah.
Okay. Good morning. Mr. Rao, have you been in the stipulation mix, or would that be Mr. Abate?
I have, as of
Wake up the
30
third.
seconds ago.
All right.
So I'm in reading the stipulations, Judge, I don't believe there's an issue, and I think that would qualify, the requirements that we need.
Okay,
I'll send it for
I'll read it in just a second.
Mr.
And I'm not the one who needs to approve it. If both sides are okay, I just want to make sure it is adequate so that the state isn't somehow stipulating away something is not required to, or it's at least sufficient for them to argue in closing that they've met the elements.
I think
I'm
on,
sending it down.
Okay,
Maybe, you're, well, you do the same situation with the printer, for their own.
I think I can print. Well, we'll come back to that. I think there is going to be a stipulation, and so what I will put in this section that you see on the screen is that evidence consists of testimony, exhibits, and a stipulation. And we'll press on to the stipulation paragraph. And I guess what I'll say, something like this. So does that paragraph as revised, that's labeled stipulations, does that work?
That covered your.
Okay.
Exactly what's all.
All right, Mr. Rao, you all right with that? That's not the stipulation, that's just what I will tell the jurors, because I think the subject matter of the stipulation or stipulations is Mr. Mosley's status as a convicted felon.
that's correct.
Okay. Take that off. Credibility of witnesses. I don't think we've had anyone impeached by, hey, you said in an interview X and in court you're saying Y and it doesn't line up. So I don't think we need that paragraph. And I am guessing, I guess we can wait, but Dr. Sullivan tends not to stray from what's in the autopsy, similar with the GBI experts. So I don't think we need that paragraph. That's why I highlighted it. Defense, do you agree?
I think we're good with that, Joe.
Okay, as in good with taking it out? Mr. Rao?
Yes, Judge, I think the only way in which this may come into play is if the defense chooses to elect
I had the same thought. So what I'm going to do is just, I'll mark it as struck out. I'm going to leave it right now, but everyone agrees that absent something changing today, it doesn't need to be in there. Defendant's choice not to testify. I will give that charge if Mr. Mosley chooses not to testify. If he does, I will take it out. Someone requested this charge about limiting instructions. I don't think that there's evidence
I
that,
can send you something, Your Honor. It's about how you can use the convicted felon. Defendant right
okay.
into the state. It's the youth.
Apparently that's a new, I just made the minor edit to, no,
For the,
the stipulation.
okay, absolutely. I'm down. Yeah, I just included it. I just included it.
Again, we never heard back. We did send out a plea to IT yesterday. Didn't hear back.
I don't know what that is.
And then they won't let you because it's not secure.
Right.
It's the whole purpose of my box.
So take a look at what is on the screen now for limited purpose evidence. Tell me
I just sent you a really long one, Judge.
how you feel about this not really long one.
Looks way much simpler than the one I sent. The same intent.
But also adequate,
I think it's adequate.
simple but adequate.
Less is more.
Okay, that's my firm belief when it comes to jury charges. Mr. Rao, are you okay with that limited purpose evidence paragraph?
Yes, sir.
Are you changing it because you think the jury won't understand?
So two things. I didn't read what Ms. Primovic sent, not because I think it's bad. I just haven't seen it yet. I try to make the jury charges, the term I use is accessible. So that if I was talking to I have a kid who just graduated from high school, he should be able to understand what I'm talking about with the jury charges. There may be people who get it even more so, but 18 and over, you're on a jury. So I try to make the jury charge accessible. I try to stay away from big words, Latin phrases, and things like that. And so I want them to understand that the stipulation that you're a convicted felon can only be used in one way. And that's to prove in 3 different counts that you're a convicted felon, not to show that you're a bad guy, that you were more likely to have shot this person or anything like that. And that's what this says, is you can't use the stipulation for any reason other than to prove this element that the state has to meet, that you in fact were a convicted felon. Because 3 of the things you're charged with relate to you being a convicted felon and having a gun. And so they're entitled, the state's entitled to tell the jury that you're a convicted felon. Not for what, just that you're a convicted felon. And your lawyers have put together some language that says, hey, everyone agrees Mr. Mosley is a convicted felon. Full stop. That's it. Nothing about armed robbery or this or that. It's a little bit more. It's a qualified offense, I think. But the point of this instruction is just to let the jurors know that's the only thing you can use it for. So yes, I'm making it simpler so everyone will understand.
Can I see what the first one said first?
I'll show you. I'll show you what I see. This is what.
I didn't alter Ms. Prinovich's. Again, I didn't even read it because I was coming up with my own language based on what the appellate courts have already suggested. I can also.
You think you took something out and changed it and made it shorter?
Well,
See, this is not.
I'm not saying that.
It says the same thing. This is what we saw. It's the name.
Are we good or we need more?
We can move on while he's reading.
Okay. The next area is justification and the use of force in defense of self. I flag this for two reasons. One, I think it'll need to be edited some should this theory be fleshed out more, but more fundamentally, I flag it because it seems like up until now, the evidence of self-defense is, Ms. Wood said it once in her opening. And I think we need as a group to assess where the record is now, knowing that the record's not closed and there could be more evidence. But I do need to hear from both sides as to whether it's appropriate to give this charge. And by appropriate, I mean, is there slight evidence in the record to support it? If there is, it's appropriate. If there is not, it's not appropriate. So I'll start with you, Ms. Wood. And I'll repeat, I know the record's not closed yet. So you may say, Judge, you need to wait. But if you already can point to things that you think get that slight evidence out there, then it really doesn't matter what else comes out.
I was gonna ask if we could revisit this issue after defense presentation.
Okay, we'll table it.
Thank you.
Just know that it's something we'll need to work through. Mr. Rao, anything you want to get on the record right now, or we'll revisit?
We can revisit. There's been no evidence.
Okay. So if you would look at the jury charge, the substantive charge for count 8, it's what's in the middle of the screen now. That tracks the language of the statute. There is no pattern charge for that, except one, there is no pattern charge. Two, it tracks the language of the statute except for element 4. I have added that notion of qualifying felony, and I did that thinking, and I now have the stipulation, I'll put it up on the screen in a minute, that there likely would be a stipulation that, in fact, Mr. Mosley has been convicted of a felony that qualifies him for criminal liability under count 8 without the jury needing to hear that's armed robbery or murder or aggravated child molestation. So read through that, please, and then let's discuss. So, defense, what's the thinking about the charge for count 8?
Yeah, we found the same research with the pattern is the same as the 131, like the pattern is the same, like you said. And then when you look up the code, this is what it says, and you took out things that doesn't apply, like for this, so we find that acceptable.
Okay. Mr. Rao, your thoughts about the charge for count 8?
I believe that's, acceptable, with the stipulation.
Okay, let's pivot to the stipulation. I think I have,
Shane, it came out funky,
Oh,
your change, when you click on your attachment,
gotcha.
it added to the top.
Let me try.
You can just send it that way.
well, here's the stipulation. If the change isn't real complicated, it's on the screen now. I'm gonna read it and then let's discuss what the concern was.
You know, do you think I can see the stipulation before they change? Or they like before they change?
I'll show it to me.
Sure, Ms. Primovic wrote it, so it should be on the screen there, and we'll look at both.
You're gonna add both indictment numbers on the same paragraph.
Oh, were there two? Did I lose? I didn't. Does it?
12C is the armed robbery.
Oh, are they both?
13C. Well,
Why did they put
there's
both?
two that are the same, but the count 7 and 9 are the same indictment.
Okay.
8 is with defendant.
Any reason, I understand it's the ship has sailed. Was there a strategic reason not just to use the 12 SC in all three of the counts?
I believe in count 8, that specific felony is armed robbery.
Correct.
And so,
You had to use that one in count 8. Why not also use it in, I guess because it shows there are two other felonies.
answer is
And it adds a count, makes it look at it.
There was, okay, that was my guess, is that someone didn't really think it through. Were the convictions on the same day?
Yeah.
That's convenient, okay.
All on the same day.
All right. So no, I didn't mean to have one go away. I didn't pick up on the fact that I just saw long number and my eyes glazed over. All right, you see on the screen, my proposed revision to the stipulation. Mr. Rao, does that language work for you?
There's something you wanted added that kept going on top of the.
Well, I think what I did was I just added, for the first one, just as I added, was a convicted felon as a predicate requirement for count 7. Then for count 3, I did the same. I changed the date because it said August 11th, so I changed it to August 14th. And then I just said that
Oh, because one of them is.
on the day of the arrest.
Got you.
Yeah, and then I just concluded it as he was a convicted felon as a predicate requirement for count 9. And I didn't do anything with count 2 or position or point 2.
Okay, take a look at what's on the screen now, and see if that captures your addition. I forgot that we had 2 different dates.
Yes, sir.
I think that's fine, Judge.
Okay,
Can I suggest one?
please.
Where it says on the last bullet point, felony conviction in case 12SC is considered. So we take out is considered, which is a qualifying.
Yes. Yep,
Thank you.
you're welcome. Ms. Primovic, have you and Mr. Mosley had a chance to look at, because I'll print this out now so everyone can sign it. Well, I'm gonna print it out and then you guys can do what you need to do. Mr. Abadi, are your witnesses here?
Yes, Your Honor.
Great. Who's going first?
Dr. Sullivan.
I'm glad she came back.
That's key.
Can you check on how many we've got? Thank you.
Well,
12. All right, who are we missing? What's up, printer?
Thank you, Your Honor. I know we're not on this subject, but Mr. Mosley would like the long version of the lineage. So we would like the long version of the lineage.
So the long version has no substance. I hear you, but the long version says, hey, sometimes there's evidence that you can only consider for various purposes. It doesn't say what those purposes are. It doesn't say what that evidence is. It leaves the jury wondering, well, what evidence are you talking about? And what are the purposes to which we're limited? So it is a template that you then plug in. First, judge tells them, this is the evidence that has a limited purpose. It could be someone's date of birth or the fact that they're a convicted felon or something else. And you have to tell the jury, here's what you have to limit it to, not just you have to guess what it's limited to. So I have reduced it in part because there's excess language that doesn't apply here. I've identified the limited purpose evidence, which is the stipulation. And I've also identified for the jury the very limited purpose for which they can use it, which is, does it prove up for count 7, 8, and 9 that you're a convicted felon and not for any other purpose? So I'll note your objection, but I'm going to stick with the language that I put together.
You don't think it's smart enough to identify that themselves? That's the thing.
It's not a smart thing. How would you know what evidence I'm talking about if I don't say what that evidence is? If I just say, hey, you know what? You've been here for 3 days and you've heard a whole lot of evidence, testimony from a dozen witnesses, a lot of pictures, maybe some documents. Some of that evidence you can only use for a limited purpose. And then I walk away. Right, but the jurors are going to say, what evidence are you talking about? Which evidence are we supposed to use for only a limited purpose? Would it be Berhalter's testimony about you were up in the attic? Would it be Ms. Bell's testimony about facial recognition software? They have no way of knowing unless I tell them. I'm required by law to say, this evidence is limited purpose evidence. You can only use it in a certain way. And of course, I have to tell them the certain way in which they can use it. And that's what the version that I put in there does.
Wouldn't that be trying to persuade the juror?
I don't think so. I think it's telling them to be careful and cautious and limited with that one piece of evidence. But your lawyer, Ms. Wood, will be able to talk to the jury about that during her closing argument, about what to do with that limited purpose evidence. And I'll say this last thing about it. Because of the objections and motions that your lawyers have made, the state is not able to talk about that it was an armed robbery conviction. If your lawyers hadn't argued for this, then the state would actually be sharing with the jury the fact that you're not just a convicted felon, but you were convicted of armed robbery. And I tell the jury, you can only use that for a limited purpose, but armed robbery, people are going to think about that in a certain way, probably in a way you don't want them thinking about it. So right now, they just know that you got convicted of something, and that's it.
It's still part of my life, and that's what they do it, so they should know that. If I feel like they do it and trying to see whether or not
Well,
it's pertaining to that.
If you choose to testify, and we're not going to have that conversation quite yet, it may be that you choose to talk about your life and what you think they should judge you on and not judge you on. My ruling is that the state doesn't get to go there. You can go there. Your lawyer could go there. Right now, your lawyer is saying, we don't want the jury to know what that other conviction was. We're acknowledging he's a convicted felon, but your lawyer has decided that it's in your legal best interest for the jury not to know that it was armed robbery. That's her professional judgment. You guys should keep talking about it. But if you choose to testify, it may be that you decide differently from your lawyer and you talk about it. The state will not be able to draw that out of you unless that door is opened up. So unless you go there, the jury's just going to know, hey, back in 2014, you got in some trouble, period. That's it. You may think they ought to know more, and you may choose to tell them more. I'm not letting the state tell them more. Okay?
I want to know why that has to do with them judging this case. This case is separate.
It is. That's exactly why they shouldn't know that it was an armed robbery. It has not, that's why it's limited purpose evidence. The only reason they know about what happened in 2014 is because the state is entitled to try to prove that you were a convicted felon. Because one of the things you're charged with is a crime for a convicted felon to have a gun. And the way you prove it is you show John Smith had a gun, element 1. Element 2, he's a convicted felon. The state's entitled to prove that, but your team is saying, we're admitting he's a convicted felon. We don't want you going into the gory details of it was armed robbery, put a gun to someone's head, or whatever happened. I don't know what happened. And the jury is not entitled to know what happened. They're just being told, yep, in fact, he was a convicted felon, which makes it a crime for you to have a gun if the jury decides you had a gun. So you're right. That other case has nothing to do with this case, other than what we call the status fact, that that case made you a convicted felon. So that in 2024, if you had a gun, you were breaking the law. And that's it. And that's how we're going to keep it unless you and your lawyers decide we want to open up that door. You open up that door, it may be that the state says, well, let's talk about 2014. How long did you go to prison? What'd you do? And I don't know that that's what you want the jury to hear about, but you and your lawyers should talk about that. Unless you decide you want to go there, the state does not get to go there. Mr. Bate will not, in his closing argument, be able to stand up and say, let me tell you something about Mr. Mosley. He is a convicted armed robber. He just can say he's a convicted felon because Mr. Mosley's acknowledged that. Yeah, I'm a convicted felon. Let's move on. Okay?
I understand that. But I also want to know, it initially was on 3 charges. Those other charges was added on after the fact that I was.
When you say it was initially, meaning when you were first arrested?
Right.
Yeah, so the police arrest you for what's immediately in front of them, probably murder and aggravated assault.
Isn't that what the jury was judging on?
Nope. After the police get the case, they hand it over to the district attorney's office and they do some more investigation and they have lawyers look at it, look at the laws, look at what the evidence looks like, and they figure out what to charge. Here's just a real simple example. Maybe the gun that was involved was a stolen gun, but the detective, he got the gun, put it in a safe place and moved on. But the prosecutor figures out later on it's a stolen gun. They could charge the person who had the gun with having a stolen gun, even though you weren't arrested for that, because no one could tell just by looking at the gun that it was stolen. Or maybe it had a switch, and so it was fully automatic, but you can't tell that just by looking at it. But there's more investigation later on. That's what they presented to the grand jury. What the grand jury indicted you on is what the jury hears about. So yeah, there are a few more charges, but they are all things that the state needs to prove. And when the state rests, your lawyers are going to say, Judge, there may be some counts that the jury shouldn't get to hear about because they weren't proven. We'll have that conversation as well. But it is typical in a case as serious as yours that the person who's arrested is arrested for 2-3 charges. And then as the prosecutor's office looks at it like, hey, there's some more we can put in here. And they're entitled to do that. But of course, they have to prove it up at trial.
What are you entitled to do?
They are entitled to bring the charges that they think the evidence supports. And that's why they have to get in front of a grand jury.
The initial charge makes sufficient.
I don't know about sufficient as maybe they're not complete.
Improve the initial charge, so they want to add extra charge.
Well, let me give you a simpler example. Let's say in this case, I'm not saying this is what happened, but let's say in this case, you shot Mr. Mathis in the leg and he was fine for a couple days. So you get arrested. You're going to be arrested for ag assault. He takes a turn for the worse and he never makes it out of the hospital and he dies a week after you were arrested. You would have been arrested for aggravated assault because there's no dead body. The case goes to the DA's office and it turns out Mr. Mathis dies as a result of you shooting him. That's now murder, but you weren't arrested for that. The prosecutor's office isn't going to not try to charge you for murder because the police only arrested you for aggravated assault. They're able to do more investigation, and if they can find evidence that justifies it, they present it to the grand jury. But in the end, what really matters is this jury, and they have to prove to a real high standard each of these charges. If they can't, they can't. Hey there.
Karen told me to bring by a hotspot.
Okay. Would a hotspot help you guys?
Yes, sir.
Great. We're on day 3 of Wi-Fi kicking people out.
Thank you, Jim.
So you come, even your example, shot to the leg, that's not murder, that's not intention to kill.
So I'm not going to argue with you a whole lot longer, but you can be prosecuted for murder if you shoot someone in the leg and they die. And it certainly you can be prosecuted for felony murder because if someone dies as a result of a felony that you commit, but you would not have been arrested for felony murder. You would have been arrested for aggravated assault. But if the person dies as a result of the felony you were committing, then you can be prosecuted for felony murder. And you are being prosecuted for felony murder. The jury may decide in this case that you didn't mean to kill anyone. but you did mean to shoot him. It was not an accident that you shot the guy. And he died as a result of you committing an aggravated assault. Legally, the jury could decide that's felony murder. Well, and that's what your lawyers are going to argue. And we don't need to have that back and forth. That's something for the jury. All right, I'm going to figure out how to get this stipulation printed. It's not printing right here. And then we'll get everyone to sign that and we'll go from there.
Judge, I just said that, want to ask for one clarification as it relates to the defendant, should he choose to take the stand, would Rule 609 not apply in terms of whether or not the substance of the convictions that he could be impeached with come out?
You are asking if Mr. Mosley chooses to testify, is he impeachable with his felony convictions?
Correct.
And not just you're a convicted felon, but isn't it true that in January of 2014, you were convicted of armed robbery and attempted armed robbery? That's right. That is something, and I'm confident his lawyers are going to talk to him about that by testifying, he creates the possibility that the stipulation would still be in there, but then there's some substance added to it, in particular, the substance of the convictions.
I just wanted to make sure.
Will you let folks know how to get onto the hotspot?
Give them the one password.
Perfect.
Just logging in. I just want to plug this in somewhere right now. It's not gonna.
Whatever place you want to pick.
You want to choose bar then?
We do have outlets on the desks.
Closer, better?
Yeah. The distance isn't gonna matter,
Okay.
but at least there, you'll be able to see the.
You don't have to go under. See, there are these fancy ones up top now,
That's not these.
trying to make your life easier.
Is it not right here? Subway?
I would love if you set this up like 1D.
Yeah, check back in a couple years.
I won't be here.
No one wants to hear that.
And you should.
Thank you, sir.
Thank you for requesting that, Judge.
You're welcome.
Thank you, Chair.
Oh, I have two.
It's the RG. We want to get down. It's not, it's mostly RG too.
Yeah.
Let me know when you all are connected.
So,
We shouldn't have let him go.
I'm just gonna. Oh, got it.
Yeah.
All right, so just to close the loop on the jury charge, we will revisit defendant's choice not to testify and justification, meaning self-defense, after the evidence is closed. But otherwise, Ms. Wood or Ms. Primovic, anything we need to talk about with the jury charge? Okay, Mr. Rao?
No, you're wrong.
Okay. Okay, Mr. Abadi, you ready for, do we have all our jurors now?
9:45, sir.
And who was that?
So. But no, but no.
Okay. All right. Then we'll sit tight. You get kind of a C for being on time, Ms. Jury. And you get like a C minus for when like, hey, let's bring them out. You go back there, it's like 10 minutes after you get back there. They're hard to wrangle. Okay.
Okay.
It's not the best thing.
Just so fairly educated.
Yes.
Okay, I'm sure.
I was wondering about.
Thank you. Just couldn't get it to print out here. All right, Ms. Wood, if you would, please come look at this and it works for you and Mr. Mosley. And that. Okay. Then let's get him ready. Don't let him get, like, I gotta go run somewhere else.
Oh, you want them out now?
Yeah.
Oh, okay.
Yeah. Not you, them.
A minus on me.
All right, observe.
in the middle of it.
Duly present and accounted for.
Thank you, Deputy Gordon. Everyone else can be seated. Good morning, ladies and gentlemen. We almost did it. You might not need to be here tomorrow, but if you are, it'd be a great Friday gift for everyone to be here when we're trying to start. We are ready with the remainder of the state's case. I think we'll fit it in before we have to break. We have a hard stop at 11:30-ish. And then we'll pick up after the lunch break. But Mr. Abadi, Mr. Rao, if you'd call your next witness, please.
State called Dr. Karen Sullivan.
Do you swear or affirm that testimony you give is the truth, the whole truth, and nothing but truth so help you God?
I do.
Go ahead, have a seat. Can you state and spell your name for the record?
Karen Sullivan, Karen Sullivan.
Morning, Dr. Sullivan.
Good morning.
Do you mind telling the jurors, where you're currently employed and what you do for a living?
I'm the Chief Medical Examiner for the Fulton County Medical Examiner's Office here in Atlanta.
How long have you been with the Fulton County Medical Examiner's Office?
I did my academic year of forensic pathology training in 2002, 2003. I stayed on part-time until October 2007, and I've been a full-time employee at the Medical Examiner's Office since 2007.
What is the purpose of the Medical Examiner's Office? What is their function?
We determine cause and manner of death of people who die of sudden, unexpected, or unexplained causes, people who die as a result of trauma, either self-inflicted or inflicted by another person.
Specifically within the Medical Examiner's Office, what do medical examiners do specifically?
Or we examine decedents or deceased individuals, either using an autopsy where both an internal and external examination are performed, or just an external examination. We also review any pertinent medical records and laboratory results, and then fill out a death certificate and complete the examination report.
And do medical examiners have specific speciality within the field of medicine?
Yes,
What is that speciality?
forensic pathology.
What is pathology?
Well, pathology is the study of disease and injury on a person's body.
And what is forensic pathology?
Forensic pathology is specifically trying to determine the cause and manner of death of people who die under those circumstances that I described before, or people who die and there's no primary care physician in order to sign the death.
And what is the sort of educational background that you had to have in order to become a forensic pathologist?
Well, I have an undergraduate degree from the University of North Carolina at Chapel Hill and a master's degree in anatomy from the University of Georgia. And after getting my master's degree, I was a high school teacher here in Fulton County for about 5 years before going to medical school at Morehouse School of Medicine here in Atlanta. And then after graduating from medical school, I did a residency in anatomic and clinical pathology at Emory, and then the additional year of forensic pathology training at the Fulton County Medical Examiner's Office.
As a forensic pathologist, do you and your colleagues at the medical examiner's office have to perform what is called an autopsy?
Yes.
What is specifically an autopsy?
An autopsy is both an external and an internal examination of a person's body, looking for signs of trauma or natural disease in order to determine their cause of death. The external examination is much like you would get when you go to the doctor or take your child to the doctor, looking at a person's height, weight, their body habitus, and any external signs of injury or natural disease. And then the internal examination is performed by examining and removing the internal organs, looking again for natural disease processes or injuries.
How many autopsies would you say you've had to perform during the course of your career?
I've performed myself or supervised pathology residents and fellows approximately 3,000 to 4,000 autopsies.
Have you ever been admitted as an expert witness?
I have
How many times would you say?
more than 100.
Just with me?
Just in here?
Yes, it seems like it.
Your Honor, at this time, the state would seek to admit Dr. Sullivan as an expert in the field of forensic pathology.
No objection.
Dr. Sullivan, you are qualified for the purposes of this trial as an expert in the field of forensic pathology. 101.
Dr. Sullivan, you had previously mentioned as part of the autopsy that one of your functions is to determine a cause and manner of death. Would you mind just explaining to the jury what a cause of death is?
Well, the cause of death means what happened to the person to cause them to die. So for example, if someone, an elderly person fell and broke their hip and died, then the cause of death would be the hip fracture. Or if someone had a heart attack, the cause of death would be the heart attack. If someone is shot, the cause of death would be the gunshot wound.
As it relates to manner of death, what is manner of death and how do you make a conclusion as it relates to what is a deceased's manner of death?
Well, the manner of death means how did the cause of death come about? So for the person who, the elderly person who fell and broke their hip, their manner of death would be an accident. Or the person who had a heart attack, their manner of death would be natural causes. For the person who was shot, we need information from the investigating agency, the police agency, to have information about the circumstances surrounding the person being shot. So if the person shot themselves, the manner of death would be a suicide. If the person was shot by someone else, the manner of death would be homicide.
Now, at the Fulton County Medical Examiner's office, once your office is in the receipt of a deceased individual's body, what is the sort of protocol from that point up until you're able to make conclusions as it relates to how that individual became deceased?
Well, our day starts with a conference where the investigators in our office who have taken the death notifications either from a hospital or from the police agency go through their reports so that the doctors who are on duty that particular day can decide for any individual what kind of examination they're going to get. After the conference is over, then the autopsy starts with photographs of the person as they are received in our office, both from their right and left sides, and then documenting any injuries that they may have before the body is cleaned. While that's happening, the doctor is also looking at the decedent's body and making his or her own notes about what they see. The body is cleaned and additional photographs are taken if necessary of injuries or natural disease that's seen externally. And then the doctor will direct the forensic technician to start the evisceration or removal of the internal organs so that the doctor can examine them again, looking for natural disease and injury. And then after the autopsy is completed, the doctor will dictate a draft report that's then transcribed by transcriptionists in our office, and eventually that report is finalized.
I'd like to turn your attention to August 12th, 2024. Did you perform an autopsy on a DeMarco Mathis?
I did.
That at the Fulton County Medical Examiner's office?
It was.
And did that autopsy include taking photographs and performing an external and internal examination of the individual's body?
It did.
And at the conclusion of the autopsy, did you author a report determining your findings as it relates to how Mr. Mathis became deceased?
I did.
Approach you with what's been pre-marked for identification purposes as states 121 through 134. you wouldn't mind taking a quick look through those exhibits and let me know when you're concluded.
I've looked at them.
All right, now as it relates to State's Exhibit 121, is that the report that you authored as it relates to your findings on Mr. Mathis?
It is.
Is that a true and correct copy of the report that you authored?
It is.
All right, this time the state would seek to admit State's 121 into evidence.
No objection.
121 is admitted into the record.
And as it relates to State's 122 through 134, are those photographs of the autopsy that you performed on Mr. Mathis?
Yes, the autopsy and x-rays that were taken for the autopsy.
Are they a fair and accurate depiction of the photographs taken during the autopsy as well as the x-rays?
Yes.
All right, this time the state would seek to move State's 122 through 134 into evidence.
No objection.
Those photos are admitted. Is the top screen on? Okay, great.
So, Dr. Sullivan, as it relates to the autopsy that you performed, and I'm going to publish State's 124, we're looking at a tag right now. What is that tag indicative of?
This is an example of a tag that's placed on the body or disaster bag of each individual that comes into our office. And it has at the top right, Mr. Mathis's case number 24-1873, his race, sex, the investigator's last name, Bess, and at the bottom, the seal number, and the seal is a plastic seal that's attached to the zipper of the disaster bag.
Does that tag always accompany a disaster bag when you are in receipt of a body?
It does, yes.
As we transition to State's 125, what are we looking at here?
This is a photograph of Mr. Mathis's body from his left-hand side as he was received in our office.
Now, in instances where the medical examiner's office does not take custody of the body at the scene, what is the protocol when that individual's body goes to a hospital in between making its way to your office?
We ask the hospital in cases of homicides or suicides to bag the decedent's hands in case there's any evidentiary material on the person's hands, and or the investigating agency wants to do gunshot residue collection kits.
And what Mr. Mathis is wearing as his body was presented to you, what is that?
It's a hospital gown that the hospital placed on him.
To your knowledge, based on your review in preparation for the autopsy report that you authored, were there attempts made by doctors at Grady to perform life-saving procedures on him?
Yes. In Mr. Mathis's mouth is an endotracheal tube, which can be used to help ventilate the lungs and get air in and out of the body. And also in his left leg, here, there's a catheter that's put into the bone of the leg in order to give fluids to try to keep his blood pressure up.
Now, the manner in which we see Mr. Mathis's body, is that how the body was presented to you after you opened the disaster bag?
Yes.
Transition to states 126. What is the purpose of taking this photograph?
Well, each person that comes into our office gets a standard series of photographs as they are received from their right and left sides, their back, and also a facial identification photograph. So this is Mr. Mathis's facial identification photograph, and on his chest is a placard that contains his case number.
What is the significance of that case number?
Well, 24 means that his death was reported in the year 2024, and his death was number 1,873 reported that year.
As we transition to states 127, during the course of your external examinations of Mr. Mathis's body, were you able to determine injuries on his body?
Yes.
What were the injuries?
There were 2 gunshot wounds of his torso, which are seen here in this photograph. There was also a gunshot wound of his left elbow.
So as it relates to states 127 and your autopsy report, you made indication of 3 gunshot wounds on Mr. Mathis's body. Is that correct?
Correct.
Now, you labeled them 1, 2, and 3. Is there a specific designation as it relates to the order in which Mr. Mathis received those gunshot wounds, or are those numbers arbitrarily given by your office just to the point of designating them?
Now, those numbers are arbitrarily given by me when I'm dictating the case.
Is it really possible for you or your colleagues to determine the order in which Mr. Mathis would have received those shots?
No.
So as it relates to the 2 gunshot wounds that we see on states 127, can you describe the injuries for the jurors?
So each of these wounds are entrance wounds. They are entrance wounds because they have an abrasion around them where the bullet scrapes the skin as it enters the body. In addition, an X-ray that was taken before the autopsy showed that there were 2 projectiles or bullets inside of his body, and there were no other wounds on his torso to make me think that a bullet had exited his body. Therefore, that makes both of these wounds entrance wounds.
As it relates to what we see on states 127, 128, is that a close-up of the wound that we see on 127?
It is.
And 129, is that the second gunshot wound on Mr. Mathis's torso?
Yes, it is.
And states 130, is that a close-up?
Yes.
Now, as it relates to exit wounds, the lack thereof, that was what allowed you to determine that these specific ones were entry wounds. Is that correct?
That is correct.
Now, if you wouldn't mind just demonstrating to the jury for a visual aid, the direction and pathway that the projectile would have gone through before ultimately resting.
Okay, I'm sorry. Do you want me to stand
please.
up? Okay. So both of the entrance wounds were on the left lateral surface of the torso. So in this area, and they moved from Mr. Mathis's front towards his back, from his left side to his right side and downward.
And where did the projectile ultimately rest, as best as you can show the jurors on me?
Well, if you consider the back of Mr. Mathis, one projectile was in the sacrum, or the part of the vertebral column that you feel right above your buttocks. And the other was in the area of the 12th thoracic or first lumbar vertebra, a little higher up.
Thank you, Dr. Sutton. Now, You've indicated that the pathway of the projectiles went specifically downwards, is that correct?
Correct.
Could that be consistent with an individual sitting down on a bench and the shooter placing his firearm in an elevated position, such as him standing over the deceased individual?
Yes, that's a possibility.
And were there projectiles recovered as it relates to the 2 gunshot wounds that we see on states 129?
Yes, there were.
Quickly go to states 134. Are these the projectiles that were recovered?
Yes, they are.
I'm gonna approach you with what's been remarked for identification purposes of states 152. Dr. Sullivan, on stage 152, are those the projectiles that we see on states 134?
Yes, they are.
How are you able to determine that?
Each one of the projectiles is in evidence box, and also in the box is a identification tag where I've written where I recovered the projectiles from and my initials.
Do the case numbers correspond to what we see the case numbers being on stage 134?
They do.
Right at this time, and have they, to your knowledge, been materially altered in any way, shape, or form?
No.
Right at this time, the state would seek to move states 152 into evidence.
No objection.
So I will admit it, I think we already have a 152. I've got the shell casings that Detective Steidel recovered as 152, but I may have written that down incorrectly. So that's coming in. We just need to make sure we've got the right numbers. 153, okay. So projectiles are 152 and they're admitted.
As we transition back to state 122, is this an X-ray of where the projectiles were recovered from Mr. Mathis's body?
They are.
And states 123, that's a close-up, is that correct?
It is.
Now you mentioned a gunshot wound to Mr. Mathis. Is that what we see on states 131?
Yes, it is.
And as we close up to states 132, we see 2 defects, is that correct?
Yes,
Is that consistent with an entry and exit?
it is.
Would you mind telling the jurors what the entry wound is and what the exit wound is and how you were able to determine both?
Okay, so this is the entrance wound. So I'll put an N for entrance. And this is the exit wound. There's not the typical abrasion around that exit wound. Because with exit wounds, the bullet is piercing the skin from the inside out. So unless the skin around an exit wound strikes clothing or some other object, you don't have that abrasion around the exit wound.
So as it relates to the wound or defect on top, this would be the entry wound
Correct.
and this would be the exit wound on bottom, is that correct?
Correct.
Now, transitioning back to states 129, the 2 gunshot wounds on the torso. Is it possible, based on your medical expertise, that the wound that Mr. Mathis sustained on his elbow could have entered, exited, and re-entered onto one of those 2 gunshot wounds that we see?
Yes, that's a possibility.
And on states 133, what is depicted?
Mr. Mathis's body was received with a number of items of clothing, one of which was this work reflective vest. And in this photograph, there are two defects with arrows pointing at them. And those defects correspond to the wounds seen on Mr. Mathis's side.
So, as it relates, to the autopsy, that was performed, in order to, retrieve the projectiles that we saw on those state's exhibits, did you have to perform an internal examination of his body?
Yes,
And once doing that, did you extract the projectiles?
yes,
And, upon, conducting your external and internal examination of Mr. Mathis's body, did you develop findings as it relates to the cause and manner of death?
yes.
And as it relates to the cause of death, what was the cause of death?
Gunshot wounds of the torso and left elbow.
And as it relates to the wounds that Mr. Mathis sustained, can you tell the jury a little bit about what Mr. Mathis, how that would have impacted him at the point in which he was shot?
Well, the projectiles in the torso had what I described as intermingling pathways. So they created a number of injuries that I couldn't ascribe to one gunshot wound, the one higher up towards the head or the one lower towards the hip. But those projectiles passed through multiple loops of his small intestine, his large intestine, also the mesentery or the connective tissue that helps to hold the intestines in place also was injured. And the mesentery has a number of blood vessels that come from the aorta to the loops of the gastrointestinal tract. So an injury or damage to the mesentery can cause a great deal of hemorrhage. And there was approximately 1.5 liters of blood in Mr. Mathis's abdominal cavity. The projectiles terminated in the vertebral column. One was in the sacrum, the other was at the junction of the 12th thoracic and 1st lumbar vertebrae. Each of those caused epidural and subdural hemorrhage. So that means hemorrhage around the spinal cord, even though the spinal cord itself looked intact.
Based on the extent of the injuries that Mr. Mathis sustained, based on your testimony, would it be consistent with him becoming deceased in a matter of minutes?
Minutes, yes, I would say minutes. Excuse me.
And as it relates to the manner of death, what was the manner of death that you were able to conclude?
Homicide.
Thank you, Dr. Sullivan. I have no further questions.
Ms. Wood, do you have questions for Dr. Sullivan?
Good morning.
Good morning.
How are you?
Good.
You testified, Mr. Rao asked you a question about the pathway of the projectile being downward, and you testified that there was a possibility of that. Is that correct?
Correct.
But you can't say for certain, correct?
I cannot.
That's all I have. Thanks for being here.
Thank you.
Any redirect?
Just to be clear, Dr. Sullivan, as it relates to the autopsy report on stage 121, do you have that in front of you?
I do.
So as it relates to page 2, position 1, the penetrating gunshot wounds to the torso, the direction of travel was front to back, left to right, and downwards. Is that correct?
Correct.
So the direction of the projectile as it impacts Mr. Mathis's body is going downwards. Would that be an accurate statement?
That is correct.
I have no further questions.
Questions from the jurors for Dr. Sullivan? Dr. Sullivan, thank you for your time. Appreciate it. Next witness?
State will call Ms. Kelsey Nash.
Okay. Thank you.
Face me and raise your right hand. Do swear affirm that the testimony you will give to be the truth and the whole truth, nothing but the truth, self God. You already have received. Can you spell your name for the record?
Kelsey Nash, KELSIENASH.
Say good morning, Ms. Nash.
Good morning.
Can you tell the jurors, how you are currently employed now?
By the Georgia Bureau of Investigation, Division of Forensic Sciences.
And, how long have you worked with the Georgia Bureau of Investigation's, Forensic Sciences with the GBI?
Since September of 2021.
Okay, and, during your employment with the GBI, for approximately the last almost 5 years, have you been in, or can you explain to the jurors what area of the GBI, are you assigned?
I work in the firearms and toolmark section.
Okay, and, have you worked in that section, the firearms toolmark section, the entire time you've been employed with the GBI?
Yes, that is correct.
And if you could, for the jurors, can you explain some of your job duties and responsibilities as a member of the firearms and toolmark section?
So firearms identification is a discipline of forensic science that pertains to determining if cartridge cases or projectiles were fired from a specific firearm. In the event that a firearm is not received, we are able to sometimes provide a determined type weapon or a DTW, which is a list of probable manufacturers that could have fired those ammunition components. I also do serial number restorations, muzzle to target distance determinations, tool mark analysis, and we do check functions on firearms to make sure they're operating as they are intended.
And in order to do all the analysis that you just described as it relates to your employment with the firearms section, can you tell the jurors a little bit about your educational background and the training that you received to do all of what you just described?
I received a bachelor's degree from Virginia Commonwealth University in forensic science with a concentration in physical evidence and a chemistry minor. Prior to being employed by the GBI, I was a contractor for the ATF as a NIBIN technician. NIBIN stands for the National Integrated Ballistics Information Network. It is a national database that law enforcement agencies can use to find possible associations to firearms to different crimes. Upon being hired by the Georgia Bureau of Investigation, I underwent a 17-month in-house training that consisted of topics that went from firearms operability and disassembly to ammunition, serial number, tool mark analysis, and firearms analysis.
Okay, and in the number of years that you, since your training with the GBI, can you tell the jurors approximately how many cases have you worked and completed in order to do the firearms and tool mark analysis?
Are you like the cases I've worked while being like working cases or in training, the practice training tools?
Since you have active training, the number of cases that you work and potentially testify like you are here today.
I've worked over 50 cases, and this would be my 14th testimony.
And in the times that you've testified, have you been qualified as an expert in firearms identification and ballistics analysis?
Yes, I have.
At this time, Your Honor, the state contender, Ms. Kelsey Nash, as an expert in firearm identification and ballistics analysis.
No objection.
Ms. Nash, you are qualified as an expert for purposes of this trial in the two related fields of firearms identification and ballistics analysis.
Now, you talked a little bit about at the beginning of your testimony what your analysis and the ins and outs of what you do when you work a case. Can you kind of explain to the jurors what you talked about briefly and how you're able to determine how a specific bullet is fired from a firearm or how a shell casing or cartridge casing is fired from a firearm if you have a firearm to do that analysis?
Yes, so I'm first going to explain what a cartridge is. A cartridge is a single unit of unfired ammunition that is comprised of 4 parts. There's the primer, the cartridge case, the projectile, and the gunpowder. The firing pin of the firearm strikes that primer and it causes a spark. That spark will cause the gunpowder to burn, which will release gases and build the pressure, causing the cartridge case to expand just enough to propel the bullet down the barrel, and then the firearm will extract and eject those cartridge cases. And so what I do is I'll take the ammunition components, and we use a comparison microscope, which is basically just 2 microscopes bridged together by an ocular bridge, much like you probably used in any biology class. And it allows me to look at 2 items of evidence under the same magnification and the same lighting. There are 2 types of characteristics I'm looking for. The first is class. Class characteristics are the characteristics that the manufacturers predetermined prior to manufacturing. So it's kind of like your car manufacturer. So you have Honda, Toyota. The individual characteristics are the characteristics that I will base my conclusions off of. Those are the individual characteristics that I will see on the items of evidence, which would be the VIN number to the vehicles. So we consider it to be the fingerprint of the firearm.
Okay, and just so it's clear for the jury, because you talk faster than I do.
It's hard to believe.
So I want to show you what's already been admitted into evidence. I'll just show you a state exhibit 142. In state exhibit 142, in that bag, there's 8, and are those what you call whole cartridges?
Yes.
Okay, and is that, in layman's terms, an unspent or unfired bullet?
Yes, that's what it's referred to, but for me, it's a cartridge.
Now, can you tell the jurors when a gun, let's say for example, a pistol is fired, can you tell the jurors what happens to the cartridge casing?
That will be extracted and ejected after it has gone through those steps of firing that I have discussed.
Now, is that the same as a revolver? Is there a difference between when a revolver is fired and when a pistol is fired?
So a pistol has one chamber that is integral with the barrel. A revolver has a cylinder with multiple chambers that revolves around a central axis that will align the cartridge as it's rotating.
Okay. And you talked a little bit about class characteristics, that being, or you're looking at the class characteristics and then you're looking at individual characteristics. And I think you said, you correlated the individual characteristics like the fingerprint of a firearm.
That is correct.
And can you explain to the jurors when a gun fires a cartridge and an imprint from that gun, which you described is imprinted on the projectile and the cartridge casing. Can you tell the jurors, do any 2 guns make that same imprint?
No, there has been studies done that have shown that it's unknown that 2 have made the same individual markings.
Now, can you explain to the jurors a little bit about what rifling is and how that pertains to the analysis and your ultimate conclusion when you are examining ballistics evidence?
So the rifling is the helical lands and grooves that you see in the barrel. They're the raised and depressed portions. You can think of them as hills and valleys. They impart spin on the bullet to make it more stable, much like when a quarterback throws a football, it's stable. It just basically makes it so it will spin and be stable. In that barrel, as it's being manufactured, the tools wear, causing those individual characteristics. So the class characteristics could be the numbers of lands and valleys. So it'd be 6, 7, and then the direction of those hills and valleys. So whether they want it to twist right or twist left. But inside those, we'll see microscopic imperfections. That would be the individual characteristics.
And so that would be correlated to what you described earlier. That's how you're able to correlate it to a fingerprint, because no 2 people have the same fingerprint.
That's not my field of expertise.
Right. Now, You said earlier that often you are asked to determine if a bullet or a cartridge case is fired from a firearm, if you receive a firearm as it relates to the testing and analysis that you're asked to do, right?
Can you rephrase that question or repeat the question?
Well, then that was a bad question, yes. But how are you able to make a conclusion as it relates to whether a firearm has fired ballistic evidence that you receive, whether it be a cartridge case or a projectile?
So when we receive firearms, we will use a water tank, which is just basically a big steel box that's filled with water in it. And we will shoot into the water tank to be able to collect our bullets. And then the cartridge cases will be caught in a net. We'll use those test fires that we created to compare to the ammunition components that are submitted. And then the individual and class from the firearm would still be imprinted on our test fires.
And when you receive a firearm, as a part of that procedure, I guess determining the functionality of the firearm that you receive.
Yes.
Tell the jurors a little bit about what that means and why you do it.
It basically is me testing to make sure the firearm operates as the manufacturer has intended to make sure that there's been no modifications and that the safeties are working properly.
Okay, and after you have received evidence and you have done the analysis that you were assigned or asked to do you memorialize your findings or conclusions in a report in each case that you work?
Yes, a report is generated.
Okay, and can you tell the juror a little bit about once you generate a report, the checks and balances that the GBI has in place for the testing that you or another firearms examiner completes within your section?
So prior to us generating a report, once I, as a primary examiner, have completed my analysis, it will go to a second fully trained examiner who will look at the same evidence I did and generate their own conclusions without knowing what my conclusions were. And then when they are finished with their analysis, they'll look at my comparison worksheet to ensure that our conclusions are in agreement. If they are, they will give me the evidence back, and then I'll start to prepare the report with the conclusions. And then once the report is prepared, it will go to peer review, where a third trained examiner will basically ensure that the documentation is supporting what my conclusions are and what the report is stating.
And there's the second person that you described as doing the same testing, I guess, that you had done previously in order to come to your conclusions and that are submitted later for the report. Is that called a blind verification?
A semi-blind, yes.
That because they don't know your conclusions and they have to do their own testing, and then the conclusions of both you and the verified are then compared to see if they're the same.
Yes, so I give them a worksheet that basically has all the item numbers that they would have to compare. So then they would without knowing my conclusion. So that's not on there. So then they would use my worksheet as like a guide of the item numbers that they are required to look at to form their own conclusions.
Now, we've been talking about evidence that you received. Can you kind of briefly explain to the jurors, prior to you starting the analysis that you are either assigned or asked to do, how does someone in your section or the GBI receive evidence from other law enforcement agencies?
So the GBI has a evidence receiving personnel where the agencies are allowed to go to this area where they can submit their evidence via lockbox, which is just like a locker. However, as soon as they close the locker, it is now locked from the outside, so only a lab personnel could access it, or they can submit it through the window to the lab personnel directly or through the mail. Once the lab personnel have received the items of evidence, they will take photographs of it and input a DOF's unique barcode and sticker. They'll then fill out a prelims custody sheet, which starts the chain of custody, and we'll enter that into our laboratory information management system. And then it will be put into an area for one of the firearm technicians to go down and pick up to bring up to our section.
And is all evidence that is received, you said a DOF number, is that a unique case number signed by the GBI for the evidence that is specifically received?
Yes, that is correct.
Okay. Now, I want to show you what's already been admitted and tendered as evidence. You state exhibits 149. So we did it 141 through 144. State exhibit 153. If you will look at those items of evidence that were previously admitted in evidence and tell me if you recognize those items.
Yes, I do.
Okay, so let's start with items states exhibit 141 through 144. What items of those that you received, and who did you receive those items from?
Those were cartridges, and they were originally inside the gun box, so they would have came from the MARTA Police Department. However, one of our technicians had removed them from the gun box.
Okay, and the gun box you're referring to, that the gun box in front of you, which is stated exhibit 149.
That is correct.
And then do you see at the top of the gun box, there's a window, but on the outside of the window, or opening it, the writing on the box,
Yes,
and does the writing show what the box contained at the time that you received it, and what you just described, the cartridges that were removed?
yes.
And now I want to go ahead and I'm just going to show you states exhibit 151, then states exhibit 160. And we will take a look at both of those items of evidence and tell me how you recognize them.
State Exhibit 160 is one of my official reports, and then State Exhibit 151 are my test fires.
Okay. And we'll start with states exhibit 151. Are those the actual test fires that you did or were able to get after you fired state exhibit 149?
Yes, those are the test fires that I made.
And as it relates to states 160, you said it was your report is looking at states exhibit 160, does it fairly and accurately depict a copy of the report that you submitted as it relates to this case and the evidence that you have already described for the jury?
Yes.
This time around, the state lieutenant was marked as states exhibit 151 test fires and states exhibit 160, which is the report or the official GBI report for.
All right, 151 test fires and then 160
Yes, Your Honor.
GBI report. Ms. Wood, any objection?
No objection.
Both are admitted.
Now, Ms. Nash, can you explain to the jurors when you received all the items of evidence that you have before you in state exhibits 141 to 144, and then the gun, basically 149, and the other items of evidence that you received, the autopsy bullets and states exhibit 152, and then do you have states exhibit 153 before you?
Yes.
Tell the jurors what is states exhibit 153?
State Exhibits 153 are the two cartridge cases that I compared.
And did you receive those from MARTA Police Department?
Yes, I did.
Okay. And can you tell the jurors, once you received all of that evidence, what are kind of the first steps that you take in beginning the analysis that you ultimately did and more or less your conclusions in your report at Stacy 160?
The first step that I did was go through and I looked at the class characteristics on the cartridge cases. I then looked at the class characteristics on the bullets, and then I looked at the class characteristics on the firearm. If the firearm has the same class characteristics as the bullet and the cartridge cases, or at least one of them, I will then go test fire the firearm to compare to those ammunition components. After I created my test fire, then I'll put the items on the stereoscope and I will compare them for their individual characteristics, which again are the microscopic imperfections. And I'll look to see if those individual characteristics are in agreement.
Okay, and so in this case, we've learned, and it's been admitted that you fired a gun and you have test fired, right?
That is correct.
And can you tell the jurors, does that mean that on your initial examination of the cartridge casings, as well as the bullets, that they had class characteristics that were in line with or matched on your initial review of the firearm that you received states of the 149?
Yes, they were in agreement.
And so after you determined they were in agreement and you fired the gun to get your test fires, can you explain to the jury the next steps that you took in regards to determining if the individual characteristics were in agreement?
Yes. So again, I mounted those on my comparison microscope and I looked at the microscopic imperfections to my test fires to determine the reproducibility. And then I compared the test fires to the items of evidence that were submitted.
Okay. And upon doing that, can you tell the jurors what your conclusions were as it relates to your comparison of the test fires, the gun, and then the evidence you received from both MARTA and Fulton County Medical Examiner's Office of projectiles?
I determined that the 2 cartridge cases and the 2 bullets were fired from the firearm that was submitted.
And just so we're clear, when you say the cartridge cases, we're talking about States Exhibit 153, the items of evidence that were received from MARTA were collected from the scene.
That is correct.
And then when you say the bullets, is that States Exhibit 152, the items that were received after an autopsy was done from the Fulton County Medical Examiner's Office?
That is correct.
Okay, so let's talk about it. What kind of gun did you, is States Exhibit 149?
It is a High Point 380 auto pistol.
High Point 380. And if it's a pistol, does that mean that it obviously ejects shell casings or cartridge casings?
Yes, it'll manually extract and eject cartridge cases.
And then in the items of evidence before you, specifically the cartridge cases in States Exhibit 153, and then the cartridges that are contained in 141 through 144, the unspent bullets. Can you tell the jurors who the manufacturer of those are?
Those would be Cellular and Bellot.
And you have States Exhibit 141 in front of you.
Yes.
Okay, and in States Exhibit 141, I can illustrate if you can't see. Can you tell the jurors what is States Exhibit 141? And can you tell who manufactured that box of ammunition?
So this is a box of ammo by Cellular and Bellot.
Okay. And you tell the jurors, what is a head stamp?
The head stamp is the area that has the markings of who manufactured that cartridge, as well as it has the primer where the firing pin would strike.
Okay, and I'm gonna, let's see, go open, take the 144. Pull one of those out.
I don't have any gloves.
I'm sorry. Time, efficiency purposes. So do you see at the back end of the bullet, is that the head stamp?
Yes.
And can you tell the jurors on the head stamp, what does it read?
It has SMB 9mm BRC.
And is that head stamp what is contained on all of the cartridges, the unfired bullets, and 141 through 144, as well as in the fired casings that you received from the Martin Police Department in the States of 153?
Your Honor, can I refer to my notes?
You sure can. And you understand his question is basically that head stamp on every cartridge case you looked at.
Yeah. Yes, it is.
Okay. So, let me ask you the question. So you said the firearm, it says at 149, it's a 380 high point pistol, correct?
That is correct.
Now, can you tell the jurors, you said the head stamp for all of, the bullets, that you analyzed is that it's got 9mm, on the head stamp, right?
It has 9mm BRC.
Can you tell the jurors, how is a 380 high point able to fire a bullet that is labeled, like you just said, 9mm BRC?
So the BRC stands for Browning Corto. Corto is the Italian word for short. So even though it's a 9mm Browning Corto, it's the exact same name, or it's a different name to call a 380 auto. So it is a 380 auto. It's just another name to refer to it. So like you have Robert and Rob. It's a 380 auto, but they can also call it a 9mm Browning Corto.
So if we go with your example, Robert or Rob, if Robert is a bullet that it's got 380 on the head stamp, and then you've got what you described as all the bullets, 141 through 144 and 153 in state's exhibits, and they have the 9mm BRC. Are you saying that they're the same caliber of bullet?
Yes, they're the same cartridge.
Could I take the magazine of my 380 high point and put in 4 380 rounds and 4 9mm BRCs and then shoot all 8 out the gun?
That is correct, because 9mm Browning Corto is exactly a 380 auto.
Okay, so let me ask you this question, just so it's clear. How is a 9mm Browning Corto different than a traditional 9mm bullet that you fired from, let's say, a 9mm Glock?
So a 9mm Luger is different than a 380 auto or a Browning Corto because the bullet has a shorter bearing surface, and the O-drive, which is what we call the nose, is more rounded on a 380 auto. A 9mm would be more elongated.
Okay, so just to not beat a dead horse here, but so are you saying that the bullets that had stamps 9mm BRC are actually 380 caliber bullets?
That is correct.
Now, let me ask you a last couple of questions. Are there times when, for example, 380 high point fires, it's fired, so the trigger is pulled, and a shell casing is not ejected, or cartridge case is not ejected?
That could possibly happen.
Okay, and can you tell the jurors, when that happens, how is the shell casing or the cartridge casing, gonna be technical, does it get ejected from the barrel of the gun?
So normally during that firing process, it would be manually extracted and ejected. However, sometimes it can get caught, whether it stays stuck in the chamber or maybe it got caught on the edge and it partially extracted and ejected, but not fully. You can have instances of that happening.
I'm going to interrupt for a second. You've now said several times, Ms. Nash, about manually ejecting, which says to me, if I'm firing the gun, then it's not automatic. I have to do something to eject the cartridge case. But is it not, in fact, automatic, meaning I pull the trigger, and as a result of me pulling the trigger, a bullet goes that way and the shell casing pops out? I don't myself, as the gun operator, have to do anything to get the shell casing out of the gun.
That is correct. Instead of saying manually, automatic is a better term for it. It will automatically extract and eject the cartridges rather than you would having to extract and eject them.
I want to be clear, I was not criticizing you. I just want to make sure this wasn't a type of gun that somehow, it's not a revolver where you clearly have to manually do everything, but it still was one where when you're done pulling the trigger, you got to do something different for the cartridge case to pop out.
No, automatic is the correct term.
All my questions, but ask way more help. That's good. All right. Thank you very much. Ms. Nash, I don't think I have any further questions at this time.
Ms. Wood?
Good morning.
Morning.
I don't have any questions for you. Thanks for being here.
Thank you for coming all the way to the podium to tell us that.
Just stretch my legs, Judge.
All right. So that,
Can I have one additional question?
as long as Ms. Wood has a chance to follow up.
Yes. Can you just explain to, or tell the jurors, in the firearm, it states it's 149. Can you tell them by looking at what the serial number is? If you want, I'll hold it, so if you don't have to touch it.
I was gonna say it's upside down-ish. P8190091.
Sorry, that's a lot.
Any follow-up based on the reading of the serial number into the record?
No.
All right, jurors, questions for Ms. Nash? Sir? Counsel, need to talk to you for a quick second. Ms. Nash will be right back.
This one.
Other side. Yes.
Ms. Nash, you described to the jury how the peer review works, that there's a blind or semi-blind, and I know there's some confusion. When you reach your results, then a colleague does similar work. Was it a blind study, as in that colleague has no idea what you concluded, or is it semi-blind? And maybe we don't know what those terms mean. So if you could tell the jury specifically how the review worked.
Yes, so when I give my verifier the evidence, I'll also send them a verification worksheet, which is a worksheet that has the items of evidence that I compared on it. So then they will have to only look at those items to form their own conclusions. So instead of having, the extra cartridges, they know to only look at those specific item numbers, but they don't know what my conclusions were. So it doesn't have like whether or not I put an identification or elimination on there.
So they know what you compared, but not the results.
That is correct.
They don't spin their wheels or run the risk of creating confusion because you compared 1 and 2 and they actually compared 3 and 4. And you might not get the same results because those are different things.
That is correct.
Okay. Is it part of your role doing the work you did in this case to run the serial number to find out to whom the gun belongs, if that information is even in a database?
No, that is not.
Mr.
Abadi, any other questions for Ms. Nash?
Very briefly, you talked about the verification process and the items that are sent to the verifier a few seconds ago. In looking at your report and then the verification worksheet you talked about, is it common with the GBI for when certain items of evidence are received from, let's say, the Fulton County Medical Examiner's Office, and then certain items of evidence are received from the Martin Police Department, that they receive different, unique DOFS or GBI case numbers?
Yes, sometimes they can submit them as different case numbers, or sometimes they can submit them as the same case number.
And when submitted and there are different case numbers, does your agency, the GBI, then link those two case numbers so the items of evidence can be compared like you spoke about today?
Yes, if agencies believe there's an association, they can link those in our laboratory information management system, so we would compare the different cases.
Thank you.
Anything else, Ms. Wood?
No, Judge, thank you.
All right, Ms. Nash, thank you for your time. You should take your documents, do not leave with the gun,
Right.
anything like that, okay? Thank you. All right, state's next witness, please.
Your Honor, the state does not have any additional witnesses to present. The state would tender, though, what's been marked as State's Exhibits 1 and State's Exhibits 2, which are both self-authenticating documents under OCGA 24-902. State's Exhibit 1 being a copy of a certified conviction out of Fulton County, case number 12 SC 115756, a certification for a felony conviction for Mr. Xavier Mosley. And then State's Exhibit 2 is similarly a additional certified conviction out of Fulton County for the defendant, Mr. Xavier Mosley, in Fulton County Superior Court case number 13 SC 118174. And we would ask that those be admitted into evidence, Your Honor.
Okay. Ms. Wood, those are self-authenticating if they are in fact certified. I'm sure you've had a chance to look at them. Any objection to having them made part of the record in this case?
Sure.
In connection with that, I believe there's a stipulation that I had discussed with the parties and it needed signatures. Has it been signed?
Not yet, Judge, but
Okay.
we'll get that to the court.
Okay.
Thank you.
All right, if you would read that into the record and we should, I guess, label it, why don't we have that be states, if you've got a sticker,
161.
161, sure. Ladies and gentlemen, Mr. Abadi has in his hands a stipulation, which is an agreement as to certain facts between the parties. It's been signed by Mr. Mosley, one of his lawyers, by Mr. Abadi. When parties stipulate to a fact, they don't need to call a witness or do anything else. You are to take that as having been proven. He's going to read it into the record, but that stipulation, the document with the words on it, will be part of the record, and you'll be able to read it and have it with you during your deliberations. Mr. Abadi?
Thank you, Judge. The State of Georgia versus Xavier Mosley, indictment number 24 SC 005-423, stipulation by the parties. Parties stipulate the following facts. Xavier Mosley was convicted of a felony on January 22nd, 2014 on indictment numbers 12 SC 115756 and 13 SC 118174 in the Superior Court of Fulton County. Thus, on August 11th and August 14th of 2024, Xavier Mosley was a convicted felon. Felony convictions and indictment number 12 SC 115756 is a qualifying felony as required for count 8 of this indictment. Signed this 26th day of June 2025 by the defendant Xavier Mosley, by myself and defense counsel Ms. Woods.
All right. With that now in the record, is the state resting?
Yes, Your Honor. At this time, the state of Georgia rests.
Okay. Ladies and gentlemen, you may recall, I mentioned when I was describing the flow of a trial, when the state rests, that doesn't mean the evidence is necessarily closed. The defense is going to have an opportunity to present evidence should it choose to, no obligation to do so. But before I turn to Ms. Wood to say, call your first witness, there are necessarily a few legal matters that we need to take up outside your presence. That naturally occur after the state rests. So I'm going to ask Deputy Gordon to take you back to the jury room. If we get through them quickly enough, you're going to come back out for a little bit so we can fill the time until 11:30-ish. Otherwise, I'll have Deputy Gordon deliver the lunchtime instructions. It'll just be a longer lunch break than I had forecast. Please don't start your deliberations yet. You've heard the state's part of the case. And that may be the only evidence you get, but we don't know that yet. Of course, you haven't heard closing arguments, which you'll hear right after lunch. And you haven't heard the law that you must apply. So with that, off to the jury room, please.
All right, for the jurors.
One time.
All right.
There appears, one person mostly, there's an E, that's a little too soon, that relates to the name.
Okay, I'll fix it. Rats. While I'm doing that, Ms. Wood or Ms. Primovic, anything we need to take up from the defense before I talk with Mr. Mosley about testifying? Okay. Mr. Mosley, I mentioned before that you and I needed to have a conversation about whether you are going to testify. Do you understand that you have a right to testify and that if you want to testify, no one can prevent you from doing so? All right. Do you understand it in the same way? If you do not want to testify, no one can force you to testify. If you say, I'm not going to testify, the state doesn't get to, well, wait, we want to call him as a witness. Do you understand that? All right. Do you understand that in just a moment, it is you who will be telling me whether you're going to testify or not your lawyers. They don't decide for you. It'll be Xavier Mosley who says, I am going to testify. or I choose not to testify. You understand that? Do you understand that if you choose not to testify, I will tell the jury that they are to draw no conclusions from that fact whatsoever. They are not to consider the fact that you enforced your right to remain silent. Do you understand? Do you understand that if you choose to testify, you have to answer questions not just from your lawyers, but also from the prosecution? In other words, you'll be subject to cross-examination. You understand that? Okay. Understanding those things, Mr. Mosley, do you want to testify in your trial?
You know, if I have a moment with my family to talk about.
Tell me what you mean by a moment and who you mean by your family.
5 minutes.
Okay. I think we can do a couple minutes, although Deputy Gordon is here. Okay. Could family raise their hands?
It's a sister.
Okay. All right. So you want to talk a moment with your sister? All right. Deputy Gordon, would we do that in lockup or would we just have everyone else leave the courtroom? Okay. If your sister comes back in a minute or two, we can do that. If she is left for the day, then we're stuck.
She was here late last night.
Okay. I think I've seen her here the entire time. So it was just bad timing.
It was bad.
What time does your phone say it is?
11:15.
Okay. The computer's way off.
Which one is way off? This one, 11:27.
Yeah, 11:22 I've got, and you can't change it on the computer, it's locked. Are you Mr. Mosley's sister? Okay, he wants to talk to you for a couple minutes. We're gonna clear the courtroom, let you guys talk. Deputy Gordon will be staying in the courtroom. His lawyers will be staying in the courtroom. Very simple topic. It's whether Mr. Mosley's gonna testify or not, okay? I'd like you to sit right there. All right, and I'd ask everyone else to step outside. I will mute the microphone in here. Ms. Rivers, are you ready?
Yeah.
All right, we are back on the record in State versus Mosley. Mr. Mosley was given an opportunity to speak with his sister outside the presence of the prosecutors or the court. I stepped off the bench, the lawyers, and really everyone else was out of the courtroom. Mr. Mosley, did you have enough time to speak with your sister? Okay, I'm gonna come back to that question. Do you wish to testify in your trial? Okay, I'm gonna have you, do you want them on the stand before the jurors come out? Okay, we're gonna get started with your testimony, do about 6 or 7 minutes of it, and then we're gonna need to stop, okay? Or does that seem like an impractical approach to the defense?
Your Honor, if the court would allow us to just start one a little early, I don't think this direct examination will take all that long, and so I don't want to load it up.
Okay. It's my schedule that's messing with things. It's nothing to do with the defense schedule. We are where we are now. I have to stop us in about 5 minutes. And so what I'm hearing you say is it doesn't make sense for flow purposes to do 5 minutes and then we're gone for an hour and a half and then it's not much more. Okay. Then I'm gonna bring the jury back out in just a moment, tell them we're breaking for lunch, and that we'll reconvene as close to 1:15 as we can. You all should be back by 1:15. I will fix the stipulation. I inadvertently misspelled Mr. Mosley's last name in one part of it, but not all the others. So I'll correct that. You guys can sign it again and it'll be 161. Do you plan on calling any other witnesses?
No, Your Honor.
So after Mr. Mosley's done, defense will rest. We'll see if there's any rebuttal. We'll still need to take a break because we have to talk about the jury charge a little bit more. Both sides should be ready to go with their closings after Mr. Mosley's done testifying. Assuming there's no rebuttal, we won't have a big old break after that. I want to flow straight into the closings. Do you have a sense yet, and I realize it's a dynamic moment because the defendant's going to be testifying, whether you'll open and close? You will open and close. Okay, great. Good to know. Can you please bring the jurors out?
But you're going to send your jury charges that we've worked on over lunch so we can look at it again?
Sure.
I appreciate that. Thank you.
Doesn't sound like we would have gotten so much if.
No, I forgot how hard it is to corral this crew.
All around the jury.
This will be quick. Don't get too comfortable. All right, you all can be seated. So we're very close to the 11:30 cutoff that I've got. I want to bring you out here just to map out the rest of the day. The state has rested. The defense will be sorting out over the lunch break if it's going to be presenting any evidence. I need you all to be back as close to 1:15 as you can make it. And then when you come back out here, either there will be a presentation of evidence from the defense, not obligatory, that's their strategic decision, no burden on the defense. And if they're not presenting any evidence, then we'll be starting with the closing arguments or summations of the attorneys. The state has the burden of proof, as I've told you about 100 times, which means they get to go first and last with closing arguments. So one of the prosecutors will be the first to address you. We'll make some of the argument, we'll sit down, and then one of Mr. Mosley's lawyers will make the entire closing argument for the defense. They sit down, and then the state gets the last word. When those words are done, I'll give you the legal instructions that I have to give you, and then you're on your way with deliberations. So that's how the afternoon's gonna look. Again, the state has rested, but we don't know if the evidence is closed. We'll figure that out when we get back from lunch. It's not yet time to deliberate. It's fine to talk about anything else. Don't talk about the case yet. There'll be time aplenty to do that. Any questions about anything? No? Please try to be back by 1:15. It's fine if you're back before then, but we won't be able to ratchet things back up until around 1:15. Thank you for your understanding.
All around the jury.
All right, Mr. Abate, anything else from the state?
I got it.
Mr. Mosley, you now have the lunch break to keep thinking about what it is you want to do. I know you said that you're going to testify. I didn't tell the jury that. So that may be something that you talk with your lawyers more about and change your mind. I'm not saying you need to do anything like that at all, but when I come back, I'll confirm that that's still the plan. If the plan's changed, the jury will be none the wiser. Okay? Please be back by 1:15.
This was clearly
It's just sort of like when you call someone like, hey, my computer's not working, and then IT shows up. I'm like, what's not working? The IT, Wi-Fi is working again. Let's find out. Ms. Wood, are you ready for Mr. Mosley?
Yes, sir.
Great. Let's bring him up, please. Oh, did I never send the jury charge again? Sorry. I see it sitting right here. Unsent.
There are your drafts.
It's not, it's just actually just on my screen. I got distracted by needing to leave. Here it comes. Better late than never. Ms. Rivers, are you ready? We're back on the record then in State versus Mosley after our extended lunch break. Thank you for everyone's patience. I know the jurors are ready because I bumped into one as I was coming back. They said they were good to go. Mr. Abate, anything before I bring the jurors in?
Nothing to say, Your Honor.
Ms. Wood, anything from the defense?
Just in that chapter.
Ms. Rios is here.
Yes.
Woo, full strength. Understand why this doesn't. So you have what? We have a,
Change.
okay, Mr. Mosley, I'm going to engage with you again. Normally I speak through your lawyers, but we had a conversation before the lunch break about whether you wanted to testify or not. You asked for time to speak with a family member. You had that time. And the answer you gave me at that point, which was a while ago, was that you were going to testify. We ended up having to break for lunch before we could start that testimony. And so I told you before we broke for lunch that I'd check in with you again and you'd be able to use, unfortunately, the almost 2 hours to think through that decision. So I need to check again so that we're making a clear record of it. First of all, you understand you have the right not to testify if you want to not testify. And you have the absolute right to testify, even though other people may be saying, don't do it. It's your decision and not anyone else's, correct? Okay. Understanding those things, do you wish to testify in your trial? No. Okay. Now you've changed your mind. I'm not asking you why you changed your mind, but I do want to make sure that I'm understanding that before the lunch break, you said yes, but now you're saying, no, thank you. I choose not to testify. Is that correct? Okay. I need to amend the jury charge, which I will do to add in that language about a defendant not testifying. And we now need to talk as a group about the self-defense charge. So I'll start with you, Ms. Wood. If you want to articulate what you think the basis is, the evidentiary basis for me to charge the jury on what I'm gonna call justification, shorthand. Sure.
Okay. Judge, we're basing that on the fact that there was a knife found in Mr. Mathis's property. There is 30 minutes of these two men sitting out on that bench at the bus station. There's no audio. Even though the state has their opinion and perspective on body language and what have you, no one actually knows what was said. And so just however slight it may be that there was a self-defense angle here, that's what we're relying on, Judge.
Okay, thank you. Who's going to argue from the state side?
And Judge, the state would puts the court that there is no evidence of self-defense. It's not illegal for Mr. Mathis to have a knife. There, you heard testimony from Michael Thompson, who said that he saw the two men, Mr. Mathis and Mr. Mosley, sitting on the bench talking like normal people. I think he said over and over again, no issues until he said out of nowhere the defendant stood up and pointed a gun and pulled the trigger at Mr. Mathis, who was ended up on the ground. And Mr. Thompson went further to say that the victim, before he went unconscious, kept saying, why? You also have no evidence. I think Ms. Wood said that there's no audio, so no one knows exactly what was said. That's exactly the point. Since no one knows exactly what was said, the fact that no one knows what was said is not evidence of self-defense, it's evidence of nothing. Therefore, it would be the state's intention that self-defense would not be an appropriate, or any charges on self-defense would not be appropriate in regards to this case, because there wasn't even slight evidence that this defendant was acting in self-defense when he stood over Mr. Mosley and shot him twice, killing him.
Okay.
Judge, can I just say one more thing?
Yes.
And just to bring to the court's attention for the record, there also was no evidence in regards to what where I left off. There's also no evidence as required by the self-defense charge and statute that Mr. Mosley was ever in danger of receiving serious imminent bodily injury or death, or there was a threat of either. So I meant to complete that, so I apologize.
Okay. Apology accepted. Ms. Wood, anything you want to add?
Yes, Judge. I think Mr. Mosley has now changed his mind again.
Okay.
So I think we will be calling him to stand.
All right. Mr. Mosley, this is the last time we're going to have this conversation. It's not a ping pong match. Ms. Wood tells me that now you think you do want to testify, and it's an important issue, so I appreciate why you are wrestling with it. Let me say this before I ask you the same questions I've asked you before. Mr. Rao brought up something involving Rule 609 one time when the jury was out of the courtroom, and we talked about it. I want to make sure your lawyers have covered it with you. Rule 609 allows an attorney to a lawyer to try to impeach, meaning to call into question the credibility of a witness with that witness's prior convictions, but only certain convictions. It wouldn't, not for jaywalking or speeding, but a felony conviction is one of the things that an attorney for the opposing side can use to try to impeach a witness. So let's say that Dr. Sullivan, the medical examiner, if she does not have a felony conviction, but if she did, Ms. Wood would have been able to say, well, Dr. Sullivan, isn't it true that you have a conviction for X? And the jury would hear about that. And then in closing argument, Ms. Wood might argue one reason why you shouldn't believe that witness is because she's got this felony for whatever it is. And I want to repeat, Dr. Sullivan has no such convictions. But you know you have two. And the state will be entitled to, I'm going to use the term confront you with them. That doesn't mean anyone's up in your face or anything like that. But to say, isn't it true that you've got a conviction for armed robbery? and a conviction for attempted armed robbery. They don't get to go into the facts and circumstances of the case, but they get to name the things for which you were convicted. Right now, those names are under wraps, and you and I had a good conversation about that. All the jury knows is that you've been convicted before, which they're entitled to know because of what you're charged with. If you choose to testify, the state, I don't know that they will, but they'll have a right to explore with you the fact that you've got those two convictions and what the names of the convictions are. Do you understand that? I'm not asking if you like it, just want to make sure you understand it. You understand that's a consequence of choosing to testify. Okay. Understanding that, is it your decision now to take the stand and testify under oath in your trial? You understand that the state will be able to cross-examine you. Okay. Then that's what we'll do. I'm going to bring the jurors in and I'll ask Ms. Wood to call her first witness, and it sounds like that's going to be you. Sure. Would you prefer that? Okay. Because you got that thing on your leg, rather than the jurors wondering what the heck that is, Mr. Mosley, I'm going to have you come take the stand now, so you're already there. And Ms. Wood, if you, actually, I'll have Mr. Mosley sign it right here. We have a new stipulation that just has his name spelled correctly. And I'm actually going to put both there so he can see the only change. Is it all right if I give him a pen for a moment to sign it? So before we get started, you know, when you're situated, you good? All right, that's what you signed before. Your name was spelled incorrectly. Now it's spelled correctly.
Oh.
You got it then? Great. And if you would sign it, Ms. Wood, and get it to Mr. Abate, he can sign it and put a new 161 on it. Get rid of that. Mr. Mosley, you'll let me know if you need a break. Okay. Deputy Gordon, once you're comfortable, he's in the right place, you are welcome to get the jury. Thanks.
Oh, yeah, we'll get that. Thank you.
Okay. That just goes with the evidence. Thanks. I understand one of our former prosecutors is coming back and will be in this courtroom. Do we know in what capacity?
For Ms. William?
Yeah.
I think she's being assigned to the DD unit. Which I don't know if that means she's coming back to you.
She says my courtroom.
You know more ways than half the guy.
Thought she might be.
You want?
You're good.
With the president, the county court.
Thank you, Deputy Gordon. Everyone else can be seated. Jurors, thank you for your patience. Well, we had a longer than expected lunch break. The lawyers and I have been talking about a few things since I returned, and I'm going to now ask Ms. Wood to, I guess, state the obvious. Are you calling any witnesses?
Yes, Judge.
All right. It looks like you're calling Mr. Mosley.
That's correct.
All right, Deputy Gordon, if you would swear Mr. Mosley in, please.
You swear affirm that the testimony you will give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Say this last name, please.
Xavier Mosley. It's Xaviermosley.
Good afternoon, Xavier.
Good afternoon.
Can you tell the jury how old you are?
Yes, I am 36 years old.
How far did you go in high school?
In high school, I made it to the 11th grade.
And where did you grow up?
I grew up in Atlanta, Georgia.
What part of town? Part of Atlanta?
Mainly the west side, but then I moved to the south side around my late teens.
I'm going to direct your attention to 2012. How old were you in 2012?
2012, I was like 24.
What was your life like back then?
It was,
I'm gonna object to relevance.
Ms. Wood?
Where the stretch.
Okay, so let's stay at the surface level, at least initially, before you dive deep in anything in particular. You also have got some documents. Are they things that the state has, or those are in fact the state's documents?
Exhibits.
Got it.
State's Exhibit 1 and State's.
Okay, and you were asking about 2014.
2012 first.
Okay, all good
Then proceed.
for now.
All right. What happened in 2012?
2012, I was working. I was a hard worker. From age 16 to 24, had mainly kept a job. I worked numerous jobs, but at the end of 2012, I kind of lost my job and things got rocky in my life. I started falling behind on bills, started falling behind on rent, and made some decisions that led me to do prison time.
Was that when you went to prison? What year was that?
That's 2012. November 18th, 2012 to be exact.
When did you get released from prison?
I got released November 17th, 2022.
Were you able to find a job right away?
Not right away. It took months to find a job. Found part-time jobs here and there. Did temp agencies, went to temp agencies, found jobs here and there, but it was nothing permanent. I was able to land a permanent job probably like 15 months after I've been released.
Is that when you started working at the chicken plant at Tip Top?
Yes.
Can you tell the jury a little bit about your job at Tip Top?
Well, it's a sanitation job. I worked in the sanitation department at Tip Top. That means after they do all the killing of the chickens and everything, I come in afterwards and we sanitize the facility, clean it, drain all the blood, clean all the chicken heads and chicken feet up, everything that they discarded, that they don't sell, and kind of prepare the facility for usage for the next day. So they can start over and do the same thing the next day.
And what shift did you work at Tip Top?
I worked the third shift, 10:30 to 6 a.m. 10:30 p.m. to 6 a.m.
Where were you living at the time that you worked at Tip Top?
I was living in Atlanta, Georgia. The same house I stayed in for the past 20 years, since 2005.
How did you get to and from TikTok?
The MARTA.
Can you tell the jury, did you also have to use another form of public transportation to actually get to the plant?
Well, yes, I had to leave the house like 7:20 and to get to work at 10:30 p.m. So I used MARTA, then transferred from MARTA transit unit to the CCT. I think that's what they call it, CCT, Cobb County Transit. So it's like two different transportation units. I transferred to one, then walked like 27 minutes from the bus stop to the chicken plant.
How many days a week did you work?
6.
You work with DeMarco Max.
Yes, I did work with DeMarco Mathis, but we worked at different parts of the factory. We both worked sanitation department, but he was in the department where he drove the forklift around. He had a totally different outfit, uniform than the one I'm accustomed to wearing.
Did you and DeMarco work the same shift?
Yes, we did.
Did you and DeMarco often ride the same bus to get to work?
We occasionally caught the same bus.
Did you know DeMarco before August the 11th, 2024?
Yes, I did.
You have any issues with DeMarco prior to August 11th, 2024?
No, I did not.
All right, so August 11th, so while we're all here today, can you tell us a little bit about your day that day?
Well, that day, I remember waking up that morning around 10:30. I walked up. I ate breakfast. I walked like a block from my house to my church called Free Gospel. I walked to church, enjoyed the church service, came home. After I came home, I kind of rested up a little bit more, cleaned up the house. Then I eventually got everything prepared to go to work that evening. So
Stop you right there. You
Okay.
said go to work that evening. About what time did you have to leave your house to get to work on time?
I had to leave like 7:30, 7:20, 7:30 around that time.
Sorry, I'm interrupting. Go ahead.
Okay. After preparing all my things to go to work, I put a change of clothes in my bag, packed my lunch in my bag, and got ready to get on the bus. Walked to the bus stop, which is a block away from my house, and waited on the bus. Caught the bus to the house. I caught the bus from the house to East Point train station. Then caught the train to Art Center station. From Art Center station, I was waiting on the bus. And then as I got to the station, you guys seen the video where,
I'm gonna stop you right there. We'll get into that, okay?
okay,
Do you remember what time you arrived at the MARTA, the Art Center station?
it was like 8:26, 8:27.
And who did you encounter when you were waiting for the next leg of your trip?
Mr. DeMarco Mathis.
What happened then?
Well, he sat next to me at the bus stop, and then we engaged in conversation. First he asked, could he had a short end of my cigarette that I was smoking. I smoke 2 packs of cigarettes a day, so I have cigarettes And that's one of the reasons we mainly got, that's mainly our interactions. Cause we really don't talk to each other, but he might need a cigarette some days. And he know I have cigarettes, so I might pass him a cigarette freely without question, just to give him a cigarette, cause he's a cool guy. We don't have problems, we don't have issues. And that's just one of the reasons we was able to talk. One of the reasons we was able to connect and relate. So he kind of asked for a cigarette. I indulged, gave him one. Previously, before that, I introduced my business, what I started, to our staff, my staff at the Tip Top Poultry, which is, I started a business called Miracle Made Mentors while incarcerated, trying to help
I don't want to interrupt you, but can you say that one more time? Miracle Made.
mentors.
What is Miracle Made Mentors?
It's like a nonprofit organization that helps educate and unite and uplift my people for the struggle we're going through. I created a program to try to help inspire Black people, young Black men, to start their own business instead of being workers and laborers their whole life. So I try to influence people the best I can and try to encourage them to do better.
And so you were telling DeMarco about this program?
Yes, I was. And that's one of the reasons I had my investor shirt on, because that day it's like that whole week I was fully focused on my business. I did extra, I cashed in on my vacation hours just so I can invest some money that week, just investing more money just so I can create more benefits for myself and live a better lifestyle, because I didn't want to be a worker my whole life. I didn't want to work every day of my life like I was doing. Just coming out of prison, I don't like just being under somebody authority and they telling me what to do left and right, day and night. So I wanted to start my own business. And that's where my investor business come from. But back to me and DeMarco talking. I was introducing my business to him, just talking about my business to him, telling him how I planned on coming to the job with a nice lump sum of money after I saved up, just to help recruit for my business. I was gonna show them that my business was profitable and I got proof that I'm making money doing my business. So it'll be a better influence for them to join in and try to see what I got going on. So it'll make them interested and I can build my business brand up.
I just want to make sure I understand you correctly. Is it fair to say you were telling Mr. Mathis about Miracle Made Mentors and your investment plans, and that you wanted to show other people at Tip Top about it? Is that fair to say?
Yes.
Sorry for that thing. So what happened next? What did DeMarco say to you?
Well, he kind of started leaning towards the wrongs, like what if this happened, what if that happened? He asked me what if, he said, he informed me that I'm not like that at the job. So he like, man, you know they don't like you. What if they try to rob you? I got a like a no nonsense kind of demeanor, and I don't take kindly to threats. So I told him I'm not worried about that because I know how to handle myself in situations if that occur. I just did 10 years in prison without getting robbed 9 times. So I'm not easily intimidated, kind of, if that's safe to say. So I was telling him about that, and we went on to talk about other things like what if some of the guys didn't like me, that don't like me, try to try to assault me and take my money. He asked, did I have the $10,000 saved up in my
Stop
bag?
for a sec. I'm sorry, hold on one second.
Object to hearsay.
To what Mr. Mathis is saying?
Yes.
Okay, Ms. Wood?
Judge, I'm trying to get his, reaction to what was said in that moment.
Okay,
That's what we're headed towards.
got it. So, Mr. Mosley, focus more on what you said than what Mr. Mathis said, but there may come a point where Ms. Wood asks you to say specifically, what did Mr. Mathis say? Then that'll give the state an opportunity to object if they think it's objectionable. But for now, I need you to stick to talking about what you said.
Okay.
Okay?
Yes. Well, you got any questions?
Oh, sorry. At this point in the conversation, you guys have been, how long have you been sitting on the bench at the train station at this point?
Probably about 15 minutes.
Did he show you anything?
Yes, he kind of, in the middle of him asking questions, he kind of flashed the object in his book bag. After he addressed that, I might get robbed at the job if I bring that amount of money to the job. He kind of flashed the object like, man, you need one of these to keep yourself safe. I didn't see the object as good, so I asked, what was that? He, out of his mouth, verbally said, it's a gun.
Your Honor. Hearsay.
I'm gonna have a different question, Judge, I'll get us out of this.
Okay.
What did you think you saw?
I really didn't know what I saw because it was unrecognizable at the time.
What happened next?
Well, the conversation kind of faded out. We kind of took a little brief break in the conversation. And we kind of moved off topic and started talking about, after that, we started talking about things that might occur and could occur. I'm trying not to say everything he said because they said don't say what he said, but.
How are you feeling at this moment after this discussion that you were a part of?
I'm really cautious and on edge.
Why is that?
Because it's a known fact that around the people that I hang around at the job that it's a bounty on my life already for like $50,000, and they say it as a joke, but I don't think it's a joke at all.
Then what happened?
Should I say what? Because the conversation it started again by him asking me questions. So should I say what he said again?
So questions aren't hearsay. You can talk about questions he asked you. If he is making statements, that's what we need to stay away from. But if he said, hey, how's your leg feel? What's the weather like? You can tell the jury questions he asked you.
Okay. Well, after he showed me the object and we moved on in the conversation, he asked me, have I been shot before? This after he showed me the object. So I was telling him, yeah, I've been shot 5 times before. So I'm really cautious about being around people with guns. So, well, it's not that I get scared around them, but I be aware. I be more aware than I am because I know now that I gotta watch this person more or closer. Does that make sense?
What did you think that object was?
Objection calls for speculation. He said he didn't know what it was.
Next question.
What happened next, Xavier?
after I told him I've been shot, he didn't ask me what would I do if he shoot me. I'm like, man, how my body feel, I probably die right now if I get shot again. So I'm cautious and I'm on edge now because now he's making insinuating remarks like he'll cause harm to me.
How did
And
that make you feel?
make me feel uneasy.
And then what happened?
Conversation went on. I think we kind of took a break in the conversation and Mr. Mathis started kind of talking to himself under his breath, but making like remarks like they might be directed towards me, but he wasn't saying them. He was saying them loud enough for me to hear, but he wasn't directing at me like he wanted me to take offense to it type.
And how were you feeling at that moment?
Uncertain. Oof. I really didn't know what to think because the remarks he was making, they kind of didn't make sense, but they kind of was believable. He was saying things like,
Objection, Your Honor, I'll hearsay.
So let's not go into what he said, again, unless the question is teed up specifically. So let's move on, Ms. Wood.
Judge. Same here. I'm gonna fast forward. Did you want to shoot DeMarco Mathis?
no,
Why did you shoot him?
I shot Mr. Mathis because he was threatening to shoot me and he was threatening to collect a bounty on my life and take my life away from me. I felt nervous and I was in fear for my life.
Did you mean to kill him?
Of course not, no.
Why did you run?
Because after I shot him, I was scared. I'm a black man with a gun who's not supposed to have a gun. I just shot a guy and I didn't want to go back to prison.
Why are you hiding in the attic?
Well, I had been in the attic for 2 days because, for one, I was thinking more guys was gonna come and try to take my life from me after they hear what happened. And I was contemplating suicide.
Did you fight with the cops when they came to your house?
No, I did not.
Were you cooperative with the cops?
Yes, I was.
One moment, Judge. Last question, you can say anything. Why do you carry a gun even though you're not supposed to have one?
Because when I got out of prison, when I was released from prison, on multiple different occasions, I was approached by guys with guns and they kind of really put guns to my head, threatening my life, threatening to accept the bounty for my life. Like a $50,000 hit on my life, and they wanted it. Some were scared to take it, but some wanted my life. They wanted me dead.
Very good for protection.
Right.
No further questions, Judge.
Mr. Abadi?
Good afternoon, Mr. Mosley.
Good afternoon.
During any questions that I ask you, if you don't understand, just let me know, okay? There's a question that I'm not making sense or you can't make sense of what I'm asking, tell me, okay?
All right, I will.
All right. Now, let's start with something I think we can agree. We can agree. You would agree, Mr. Mosley, this is your book bag, right?
It is.
Okay. And you would agree, stated that 149, this is the gun you used to shoot DeMarco Mathis.
Yes, it is.
So it's the gun that you were carrying all day, throughout the day on August 11th, 2024, correct?
Yes.
And you would agree in State Exhibit 140, these are the shoes that you had on August 11th when you shot DeMarco Mathis, correct?
Yes.
And we can agree that State Exhibit 200, this is the shirt that you were seen wearing on August 11th of 2024, correct?
Yes, it is.
Okay. And you can agree that this was the Falcons cap that you had on in all the videos, and the video where you shot DeMarco Mathis, correct?
Yes, it is.
Correct. And then we can agree that when the State's Exhibit 150, this is the plaid shirt that you were seeing either August 5th or August 9th at the East Point Market Station when you used the grease card that was collected when you were arrested on August 14th, correct?
That's correct.
All right. So we can agree that, and I want to show you State's Exhibits 44 through 56. You'll just flip through those still shots. Okay, would you agree that in State's Exhibits 44 through State's Exhibit 56, those still shots are all pictures of you, correct?
That's correct.
And some of those still shots are from the day that you shot and killed DeMarco Mathis, correct?
That's correct.
And other of those still shots are pictures of you at the East Point Market Station. They're on August 5th, August 9th, or August 10th, correct?
Yes.
And lastly, some of those still shots are pictures of you either on a bus or a MARTA train, also on August 11th, the day that you killed DeMarco Mathis, correct?
Yes.
All right. And can we agree that the firearm State's Exhibit 149, that is the same firearm that you took up into the attic when you were hiding from the police, correct?
Yes.
Okay. And how long had you had that firearm?
I'd say probably 8 months
Okay. And where'd you get it?
off the street.
Okay. And we can agree that by law, it's illegal for you to possess, own, carry, be an armed breach of a firearm, correct?
Yes.
And despite that, you still chose to carry a firearm, sounds like on your person at all times, correct?
Yes.
Okay. And it's illegal for you to carry a firearm because you're a convicted felon, correct?
Yes.
Okay. And you were convicted of committing an armed robbery and an aggravated battery and possession of a firearm during the commission of a felony from October of 2012, correct?
Yes,
And you were also, and that's in case number 12SC 115756 out of the Fulton County Superior Court. So where we are here today, correct?
yes. I'm not sure about the numbers, but yes.
Okay. Well, I'll have you look at, you would agree that since the one, the copy of the certified conviction for your armed robbery from October of 2012, correct?
Right.
And can we also agree that you have a second felony conviction in case number 13SC 118174 out of Fulton County for on November 18th of 2012, attempting to commit, where you're charged with committing 2 armed robberies and, or excuse me, 3 criminal attempts to commit armed robberies and carrying a firearm during the commission of those felonies, correct?
Yes,
Okay, and you were convicted of both of those counts, and for both of the convictions, you agree that Exhibit 2 is a certified conviction of your second felony convictions involving criminal attempt to commit armed robbery.
yes,
Okay. And you said on direct, you went to prison for those offenses for, you said 10 years?
that's correct.
Okay, and you said, I believe you were released at November 17th of 2022, correct?
That's correct.
And when you were released in November of 2022, you knew that it was illegal for you to ever carry a firearm again, correct?
Yes,
Okay, and you said on direct, I think, talking about working under people, you didn't like authority. Do you remember saying that?
I do.
And the authorities had told you you were not allowed to carry a firearm, but you chose to do so anyways, correct?
Yes,
Knowing that you were breaking the law every time that you were in arm's reach of a firearm.
yes. The authority is not there to protect me, sir.
Okay, but you would agree that the law is the law, correct?
Yes,
And a law is something you have to follow, correct?
yes,
The law is something I have to follow, correct?
yes,
The law is something that these jurors have to follow, correct?
yes,
And if you don't, there's consequences for violating the law. Can we agree on that?
Yep.
And so you said you got that gun approximately 8 months from the day you killed DeMarco Mathis?
yes,
Okay. Now, you heard the testimony, or do you know, you saw Officer Williams testify, correct?
correct.
And he was your felony community supervisor, correct?
Yes,
And he told you you weren't allowed to have a gun, correct?
you did.
And you were to check in with him and, make sure that you were doing the parts related to whatever program you had been asked to complete as a part of your release from prison, correct?
Yes,
And carrying a firearm is a violation of all of the rules and tenets of your felony supervision, correct?
yes.
And yet you still carried one.
First law is self-preservation.
Excuse me?
First law is self-preservation. I got to save myself before I consider any other thing.
Okay. Well, wouldn't you agree that part of saving yourself is staying out of prison?
I would agree with that. Saving myself is part of staying alive.
Okay. And would you agree that part of saving yourself is staying out of situations where you have to save your life?
How can you do that?
Oh, I get to ask the question, just got to answer them.
All right, let's ask a different question.
Now, you talked about, I think on direct, your business that you either were starting or getting started in the investment business, correct?
Yes,
And you said it sounded like the tenets of that business was a form of mentorship for younger men.
Yes,
And you would agree that a mentor is somebody who somebody can look up to, correct?
that's right.
Who they can go to get the right answers,
That's right.
who they can go to set a good example, correct?
Yes,
And you would agree that after getting out of prison and breaking the law by carrying a firearm is not setting a good example, correct?
yes.
Now, we heard and we saw during last couple of days that not only did you carry the firearm, but you had an extended magazine or magazines that went with your firearm, correct?
That's right.
And an extended magazine is something that allows you to carry more bullets or ammunition when or inside or with your firearm, correct?
That's right.
All right. Now, let's talk about August 11th, 2024. You said, it sounded as if on direct that it was what I would characterize as a normal day, right?
Yes,
Breakfast, you went to church, you rested, you cleaned the house, right?
yes,
And then you got ready as you did every Sunday through Friday from 10:30 p.m. to 6 a.m. to go to work, correct?
well, I got ready from 7:30.
Okay, so that was a bad question. So you got ready to go to work and you left at approximately 7:30, correct?
Yes,
Like you did every Sunday through Friday when you were going to work your shift at Tip Top Poultry from 10:30 p.m. to 6 a.m., correct?
that's correct.
And you took the normal route that you would typically take from your house to get to the art center station, correct?
That's right.
And that's the route that we saw you take through the video surveillance from the bus that you picked up either on McWilliams or Hartford Street, correct?
Right.
And then you rode that bus to the East Point MARTA station, correct?
That's correct.
And then from the East Point MARTA station, you got on a northbound train 223, to head to the Art Center station, correct?
Yes,
And once you arrived at the Art Center station, you went and waited in the bus loop, correct?
that's right.
And in all of that time, the public bus, the public train, and all of the public stations, you were illegally carrying that firearm, right?
Yes,
And you sat down on that bench with DeMarco Mathis, correct?
he sat down with me. I was
Okay.
there first.
Y'all were seated at the bench together, whether you got there first or he got there first, for approximately 30 minutes, right?
Yes,
And he didn't know you were armed, correct?
no,
Okay. And where did you carry your gun?
my pocket.
Okay, in your pants pocket?
Yes,
Okay. And you told this jury today that y'all got along, correct?
yes,
And you've never had a problem with him, right?
that's right.
And I think you said he's a cool guy, no issues. You're able to hang out, connect, and relate, I guess, because you both like to smoke cigarettes.
Yes,
Okay. And that day was when you saw Mr. Mathis at the in the bus loop of the Art Center transit station. Was no different than any other day that you'd see him, both of you going to work, right?
yes, it was different. That was the first time we ever sat beside each other and talked for a long period of time.
Okay, so it's your testimony that on this day, August 11th, the day that you shot Mr. Mathis, was the first time you guys had sat together.
Yes,
Okay, and you would agree, and as you told us earlier, when he sat down, it was no big deal, you had no issues, correct?
right.
And you continue to have no issues, right? As you continued to talk in the beginning, right?
it turned into an issue
Okay. How did it turn into an issue?
because he started getting aggressive and threatening.
He started getting aggressive.
Yes.
How did he start getting aggressive?
He started pointing device at me that he said was a gun.
And now he said it was a gun.
He told me he had a gun. Yes.
Okay. So it's your testimony here today that Mr. Mathis, while y'all were seated at the bench, told you he was carrying a firearm.
That's correct.
And I believe your testimony on direct was he opened his bag and flashed something at you, right?
Yes.
But you didn't see what it was.
No.
And Ms. Woods asked you a series of questions about how you were feeling. You remember that?
Yes.
Said you were uneasy, right?
Right.
Feeling uncomfortable, right?
Yes.
But you kept talking to Mr. Mathis, right?
Yes.
And you would agree prior to that day, you had never had any sort of issue with Mr. Mathis.
Right.
And you had been working the same shift, the same company since March 3rd of that year, correct?
That's correct.
So March, April, May, June, July, August, so roughly 6 months, you had no issue with Mr. Mathis, right?
Right.
And just on this day, out of nowhere, it's your testimony that Mr. Mathis sat down and flashed something that you couldn't see, but told you it was a gun, right? That's your testimony.
That's correct.
Okay. And you told Ms. Wood again that you felt uneasy, didn't feel good, right? Yes or yes or no?
Yes.
Okay. And you would agree that you weren't chained to the bench, right?
Right.
You weren't tied to it.
That's correct.
Nobody was holding you down, right?
Right.
No one was forcing you to sit there.
Right.
You remained seated there though, right?
I did.
Despite what you're telling us here today for the first time about you feeling uneasy and Mr. Mack saying you allegedly had a gun, right?
Yes.
A gun you never saw, right?
Right.
And at any point during that conversation, you could have got up and walked away, right?
And go where?
My question is, at any point during that conversation, you could have got up and walked away, yes or no?
Yes.
But you didn't,
Right.
even though you were feeling uneasy, right?
Yes.
And you were feeling threatened, right?
Right.
But you stayed there.
That's correct.
Tell me how that makes sense.
Kind of like right now, I'm in the same situation.
You're saying right now you're in the same situation that you were on August 11th of 2024.
Kind of. The feelings kind of mutual.
Okay?
I don't want to be here. I'm getting questioned and interrogated by you, and I haven't had any prior relationship with you that seemed threatening or made me feel uneasy.
So is it your testimony that at this moment you believe I threatened you?
I believe you on the side that's trying to take my life away from me.
My question was, at any point during this time you and I have been having this conversation, have I threatened you in any way?
No,
Have I shown you a gun or pointed a gun at you?
of course not.
That's the only gun that I've shown you, the one you used to kill DeMarco Mathis on August 11th of 2024.
Yes.
But yet you feel threatened by me here today,
Yes.
just for me asking you questions about what you did on August 11th of 2024.
It was not about the questions you asked him, about what you are trying to do.
Okay. Hold you accountable?
Yes. Yes.
You believe that every person has to be held accountable for the actions that they take, correct?
Yes. And I take full responsibility for my actions.
You take full responsibility for shooting an unarmed man, correct?
He wasn't unarmed at the time I shot him. He made me believe that he was armed.
You would agree that the evidence has been that Mr. Mathis didn't have a gun, correct?
I know that now, but at the time, he made me believe he had one.
Okay. You would agree that you have to be held accountable for shooting Mr. Mathis as he sat there on the bench, correct?
Yes.
And at the time that you shot Mr. Mathis, he wasn't attacking you, right?
Yes, he was.
Time that you shot Mr. Mathis, did he lay any hand on you?
I didn't lay a hand on him.
Laid a bullet, you laid multiple bullets into his body, correct?
That's because he was aiming the object at me, making me think that he would put multiple bullets in my body.
My question to you was, at that point that Mr. Mathis physically touched you,
He did not.
and you would agree that it's convenient that you sit here today and say that Mr. Mathis threatened you, knowing that there's no sounds to the video, correct?
I know that now.
You know that now, right?
Yes.
You didn't know that then, right?
No.
Okay.
I thought everything at the train station was getting recorded.
You thought everything at the train station was being recorded?
Yes.
Okay. But yet, so you thought everything at the train station was being recorded, why didn't you call for help?
Because the threat was immediately right then and there.
And you agree you fled the scene, right?
Yes.
But yet you knew everything was being recorded?
Yes.
So why'd you flee the scene if you knew every action that you were doing was being recorded? Help me make sense of that.
My intentions was not to kill Mr. Mathis, and it was only to defuse the situation and disarm him. I wasn't aware that he wasn't going to be able to get up and follow me and pursue me.
Okay. And so you, it's your testimony that when you shot Mr. Mathis, you believed he was going to harm you in some kind of way, right?
Yes.
And you felt that way even after you shot him, right? Is that what your testimony is?
Yes.
But yet, after you shot him, you didn't immediately run, did you?
Yes.
No. After you shot him, you took the time to go back and get your bag from the bench, did you?
My bag was nowhere except a step away.
Step away, but a step closer back to Mr. Mathis, correct?
No, a step away from him. He was further away.
But you were so afraid that Mr. Mathis was gonna hurt you, you still took the time to grab your book bag?
Mr. Mathis was on the ground by the time I grabbed my book bag.
My question is even though you just said that you were afraid after you shot Mr. Mathis, he was still gonna harm you in some way, yet you still went back and got your book bag, correct?
I did.
Okay. But you had not seen a gun at any point, correct?
Thought I seen a gun. I thought the object he was waving at me was a gun.
So now it's your testimony that during the time that you and Mr. Mathis sat on that bench, he waved a gun at you?
Mr. Mathis pulled out the object from his bag and began to conceal it with a phone. He covered it up and made me think that he had a gun.
Show me with your bag. How do you do it?
They do what?
How did you do it? Tell me how he showed you the gun, how he pulled it out. Show.
I wasn't watching him when he pulled it out. By the time I turned my attention back to him, he had his cell phone in his right hand and he had an object in his left hand and he was covering it up like this, aiming it like this at me, pointing, saying what he would do. He would shoot me and kill me.
Now
This made me in fear for my life.
So now it's your testimony that Mr. Mathis pulled the gun from his bag, obscured it, or locked it with his phone, and pointed it at you, and then threatened you with it?
That's correct.
Okay. And at what point during this 31-minute conversation did that happen on video?
Like seconds before he got shot.
Seconds before you got shot.
Yes.
Okay. And so if this was seconds before you shot him, it's your testimony that the gun was in his hand with a phone over it, correct?
Correct.
Guys, defendant could stand up, could you show the jurors where, Mr. Mathis had this gun on his side, with the phone obscuring it or covering it?
Hold on one sec. Are you okay if he just does it while he's seated?
Sure.
Okay, so you're there, you can keep your hands up. Why don't you stay seated? And, I don't know if you want to give, I don't have a phone he can borrow, as a demonstrative aid.
He had the phone in his right hand. He had an object in his left hand.
Let's let my phone be an actual phone, and let's let Mr. Rao's phone be this alleged gun, okay?
Okay.
Now show the jurors how Mr. Mathis had his gun and his phone obscuring.
He had it like this, covered up. He was aiming it like this at me. Like,
So hold it up high. I know he was holding it low. I hear you there, but that way the jurors can see it. So hold it up a little higher so they can see what you're doing.
see what I'm doing? He had the phone like this. He had the object in this hand, waving it at me, saying, "I shoot you. I kill you." I don't know what object it is up under the phone. I was in fear for my life.
Okay. And, well, I don't mean to harp on this, but you said you don't know what that object was. You just said, right?
That's correct.
But you just said that it's a gun being obscured by a phone. How do you know it's a gun?
Judge,
So
I'm
he
gonna
made me
object.
believe. it was
Stop for
good.
1 second. When you hear an objection, you got to stop so we can work through it. Yes, ma'am.
Seems like this is asked and answered at this point.
Okay. If you want to ask one last time, you can, but then we'll move on.
So, how did you know it was a gun if you now have demonstrated for the jurors that it's out of his bag and it's pointed at you, or you see it pointed at you? How did you not see the gun?
I said, he told me it was a gun. He made me believe it was a gun. He concealed it and pointed at me, made me believe that he had a gun.
You would agree, Mr. Mosley, that you and Mr. Mathis are sitting like right next to each other, correct?
Right.
And to the point where you're almost touching, right?
No, we're not that close.
Okay, how close would you say that you and Mr. Mathis are?
We're like 5 feet away from each other.
All right, so are you from where you're seated to where I'm standing right here next to this air filter, or is it closer?
Yes, kind of like this.
Okay, and you said that this act of him pulling this gun that you didn't see and obscured by a phone, this all happened seconds before you got up and stood over him and shot him, right?
Yes.
So you would agree that if it happened seconds after he allegedly brandished, pointed, showed a firearm and threatened you, that when you shot him, the gun would have still been in his hand, correct?
Correct. Or it fell out.
Or it fell out
Yes.
and fell out where?
Probably landed on the bench, probably landed on the ground in front of the bench.
Well, you went back towards the bench to get your book bag, correct?
I leaned over and reached and grabbed my bag.
Right, when you leaned over and grabbed your bag, you never saw a gun, right?
No.
And after you shot Mr. Mathis and he rolled from the bench to the floor, never saw a gun around him or in his hands, correct?
Never looked back.
And after you shot Mr. Mathis, you fled from the Oxford station, correct?
That's correct.
And you told us today you went home, right?
Yes, I made my way to my house.
You what?
I made my way to my house.
Okay, and August 11th was a Sunday, right?
Yes.
And earlier that day on Sunday, your girlfriend, Erica, broke up with you, right?
No, that's incorrect.
Okay,
I broke up Monday.
right. Well, you heard her testimony when she came in yesterday, right?
Yes.
And you heard her tell the jurors that she broke up with you because you accusing her of infidelity the Sunday before you were arrested, correct?
Yes, I heard that. I wanted to object, but I couldn't.
Okay. Well, you would would agree the Sunday before you were arrested was the day you shot and killed Mr. Mathis on the 11th, correct?
Yes.
And you don't dispute the fact that you had been accusing her of infidelity, correct?
No.
No, you don't dispute that?
No.
And you would agree that not only had you been accusing her of stepping out on you, but you had been accusing her of doing that with allegedly people you worked with, right?
Yes.
And you worked with Mr. Mathis, right?
That's correct.
Okay. And a few days later, on the 14th, in the morning hours, you heard the police knocking on your door, correct?
Well, I heard the bullhorn.
Okay? And you heard the bullhorn where the police were announcing this is the Atlanta Police Department, correct?
Yes.
Heard that they were looking for you, correct?
Yes.
And Ms. Wood asked you about whether you cooperated with the police. Remember that?
Yes.
And you would agree that before they even entered your house, on the bullhorn, and then they knocked on the door several times, asking you to come out of your home, correct?
Yes.
But you didn't, right?
No.
Stayed in your attic, hiding with your gun, correct?
Yes.
And you stayed in the attic for about an hour and a half before coming down, correct?
I don't know what time it was after they got there, but I was in the attic about 2 days.
Okay. All right, so you would agree then if you had been in the attic for 2 days, you, well, there's no bathroom in the attic, is there?
No. Yeah.
You would agree in the photograph, there's no pictures of you, I guess, having to use the restroom up there since you've been there for 2 days, right?
Objection.
Hold on one second. Yes, ma'am.
Relevance?
Goes to credibility.
Okay. Streamline it, but you keep going.
Yeah, I won't ask a question and a half, but
Okay.
so you would agree if you'd been up there for 2 days, you would have had to use the restroom up there, right?
It's my house. I got free reign over my house.
So you came down from the attic, is what you're saying?
Yes.
You had been in the attic, like you led us to believe, for 2 continuous days.
No, not the whole 48 hours. I
But you
came
would
down to
agree,
get me some food. I came down to use the restroom. I went back up.
you would agree on direct, you didn't say any of that, right?
Right.
That you've been in the attic for 2 days.
Yes,
And when I asked you, you said you've been in the attic for 2 days.
that's correct.
All right, so, at some point, you were in the attic when the police arrived, and you finally came down, right?
Yes,
And before you came down, you left, your gun in a closed, bin, right?
yes,
And when you came down, you didn't tell the police, hey, there's a gun upstairs in the bin, right?
no, I did not.
Right. You didn't think they'd find it, right?
I knew they'd find it.
Okay.
Bin wasn't closed.
Okay. So you heard the testimony of, Detective Stidle, correct?
Yes, I did.
You heard him testify that when he went up to that attic, he had to open that bin in order to find the gun. You heard that, right?
Yes, I did.
Okay. So like Miss Erica, he's not telling the truth either, right?
That's correct.
All
I
right.
wanted to object to that too, but I couldn't.
Right, you don't get to object.
Right.
That's not your role in the process.
That's why I didn't do it.
Good. Good work.
And after you were arrested, you were taken to Martyr Precinct, right?
Yes,
And at that point, Detective Stidle and one of his fellow detectives, now Sergeant Garvin, came in and had a conversation, right?
yes,
And do you recall, before they had that conversation, they asked you how old you were, right?
yes,
They asked you about your education level.
yes,
You remember telling them that you had taken some college level classes, right?
yes,
And they asked you, did you understand the process and what they were talking to you about, right?
they did.
You indicated you understood, right?
Yes,
They asked you if you were under the influence of any alcohol, drugs, or anything that would affect your ability to understand what they were talking about, right?
Right.
You told him you weren't and that you understood, right?
Yes.
He read you your rights, right?
Yeah.
And you agreed to have a conversation with him, correct?
Yes.
Do you remember, he asked you first what happened, and your response was, what are you talking about? Remember that?
That's not the first thing he asked me.
What's the first thing he asked you?
I don't recall right now, but I know that was, he asked me that after he started asking about my girlfriend. That's when I told him, that's when I said what I said, because he went off from the incident to my personal life. He tried to go back to it, and I'm like, you trying to confuse me and mix things up.
Okay, you would agree that it's recorded, right?
Yes.
On that recording, one of the first things Detective Steidel says to you is that we're here today about the Art Center. And your response is, what happened? Or what are you talking about? Excuse me. He asked you what happened and you said, what are you talking about? You don't remember that?
I have to hear the recording again.
Okay. And do you remember telling the detective, after he asked you again, about what happened, you said lots of stuff happened. You remember that?
Yes.
And he asked you, made a statement, tell me what happened when you were talking to DeMarco. You remember hearing something like that during the recording?
Yes.
And you responded with lots of stuff was going on, outside forces, and you say something about there's a lot of energy in people, right?
Yes.
And the detective specifically asked you with DeMarco. Do you remember that? You do?
Yes.
And do you remember what your response was?
I don't recall.
Would it surprise you that on that recording you said, no, not with DeMarco?
Maybe.
That would surprise you?
It would.
It would?
Yes.
Okay. And would it surprise you? He then asked you a series of questions about how you knew DeMarco. Do you remember that?
Yes.
You remember telling him you know him from the job, from working at Tip Top. You remember that?
Yes, I did.
And you remember talking to him about the fact that there were times that you guys worked the same shift at the factory, right?
You always work the same shift.
Okay. And that you would run into each other from time to time, right?
Yes.
And do you remember the detective specifically asking you what you would define? First, he says your friendship, and then he says your relationship with DeMarco. Do you remember that?
Yes.
Do you remember what you said in response to that question?
I think I said it's like a cordial relationship.
Okay. You said it was a cordial relationship, right?
I believe so.
And he asked you, he said, so it was cordial, it was cool, and you'd never had an issue with him or anything like that, right? And you said, what?
Yes.
Right. You said yes, that you had never had an issue with him,
Right. No.
that you'd never had a problem with him.
That's correct.
And on this day, when you had the opportunity to talk to the detective who's asking you what happened, you told him nothing happened, right?
Yes.
You didn't tell him that what you told us today, that there was any type of beef, right?
There was no type of beef.
Okay. You didn't tell the detective what you told us a few minutes ago, that Mr. Mathis threatened you, right? You didn't tell him that?
He got off topic, so I told him I didn't want to continue the conversation because he started bringing other stuff up in the conversation.
Okay. So fair to say you did not tell him he threatened you, correct?
Right, I did.
And you didn't tell him that he held a gun, obscured or blocked by a phone and pointed it at you and threatened you, right?
No, I did not tell him that.
Never mentioned anything about feeling unsafe, right?
It never came up in the conversation.
You never mentioned him that you ever felt uneasy, right?
We only talked about 2 minutes. The conversation not that long.
Okay. My question is you never told him any of that in those 2 minutes, right?
No.
And you never mentioned to Detective Steidel, that you were in fear of receiving imminent bodily injury.
Objection, Judge. Again, we've covered this, asked and answered.
Okay, you haven't, so you're establishing, I understand what you're establishing, last one in that area.
Okay.
Okay.
Can you repeat your question?
Yeah, so you never explained or expressed to the detective that day when you were talking to him that you were in fear of receiving serious bodily injury or were in fear of being killed by Mr. Mathis, correct?
No, I didn't tell him that.
And you also remember during that interview, you identified yourself from a still photo that we talked about during that interview from you being on the bus on August 11th of 2024, right?
Yes.
You would agree that during that interview, there was nothing that prevented you from telling the detectives what you told us today.
I mean,
Right.
You are objecting. What's your objection?
I feel like Mr. Abadi's getting mighty close to something that I am going to object to. I don't want to have to make a motion here, Judge.
Okay.
I don't know what the motion would be, but
Well, I have a inkling, so why don't you have this be the last question about what Mr. Mosley discussed or didn't discuss during his time with Detective Steidel?
Mhm.
Want to repeat the question?
yes. So on August 14th of 2024, when you spoke to the detective, you would agree that that was an opportunity for you to tell the detectives what you told all of us a year later here today.
Judge, I'm objecting to this.
Okay, overrule.
I was under the impression that he already knew from the video footage.
During that interview, you didn't tell him he should look at the video footage, right?
No, I didn't.
You didn't mention anything about the video footage, right?
He had a picture of me showing me that he knew everything. I was thinking he was aware of everything that was going on.
Well, do you remember your response to him showing you the picture from you on the MARTA bus? I think it was bus 1830, the initial, I guess, bus that you have to take in order to get to the East Point Station. Remember your response?
Yes.
What was it?
I think I asked him, was that a trick question?
Right. You didn't say, did you look at the other parts of the video, right?
No, I did not.
Okay, but you could have, right?
Why would I? He's the detective.
But you could have told him that, right?
Could have.
You chose not to. Right?
Yes.
Okay. And during your direct examination, you said something about I think you said it was a $50,000 bounty on your head, I think is what you said. Remember that? Right. And correct me if I'm wrong, didn't you say that Mr. Mathis wasn't a part of whoever took out this $50,000 bounty, correct?
What do you mean?
Did Mr. Mathis take a $50,000 bounty on your head?
He works with me. Of course, he didn't put the $50,000 bounty on my head.
Okay. So my question was, is he involved at all with this alleged bounty that was on your head?
He could be trying to receive the bounty.
But you didn't have any information that he was trying to receive any bounty, right?
I don't know who's trying to accept the money.
Okay.
I don't know who's out to kill me. I just know somebody's out to kill me. It could be anybody. It could be you, Mr. Abate.
Okay. We've never met before all of this case, right?
People who put the money on my head got power. I probably don't meet half the people they know.
Okay. So now it's your testimony today that I could be someone who put the $50,000 bounty on your head.
So you're not the one who did it, but you could be wanting to accept the money.
You know how crazy that sounds?
Judge, I'm gonna object here.
Okay, argumentative.
I'll withdraw the question.
That's, you don't get to withdraw, just don't say something like that again.
So, well, I'll ask you this, is it your testimony that you legitimately think that I could be somebody who would,
Let's move on from your potential connection to it.
so you had received no information on August 11th, 2024, that Mr. Mathis was trying to collect $50,000 for the bounty on your head, right? You had no information about that.
Judge, I'm objecting again. This calls for speculation.
So overruled, but last question about Mathis, any connection to bounty?
I know the Tip Top employees all have knowledge of this.
How long had this bounty been on your head?
To my recollection, since I was released from prison.
Did it flow from something that went on in prison, this bounty?
So it flowed from the guys I robbed before I went to prison.
So it's your testimony that the bounty began in November 2022 when you were released from prison?
Yes.
Remember a few minutes ago, seconds ago, you said the bounty was something that originated from you working with those at Tip Top, right?
No, it didn't originate for those guys. They probably be the ones trying to collect it, but it didn't start with them. They
Okay.
don't have money like that. They work with me.
So is it your testimony that from the day you started at Tip Top on March 3rd of 2024, it was your belief that people at Tip Top were trying to kill you?
No, I believe that people in the city was.
Well,
I had to find means to protect myself way before I started working at Tip Top.
you agree Tip Top's in Marietta, Cobb County, it's not in the city, right?
Well, I'm not from Marietta in Cobb County.
Okay. And at any point while working at Tip Top, when you thought people who you work with were trying to fulfill this bounty so they could get $50,000, did you report this to anyone who worked at Tip Top?
I hardly report anything because I have bad trust issues with the law. I have bad trust issues with people.
Okay. Well, you would agree that Mr. Terry Bruce doesn't work for the law, right?
Yes.
You would agree that your direct supervisor didn't work with the law, right?
I don't. This was my first time seeing Mr. Bruce ever.
Okay.
He worked at the same facility as me.
But I guess my original question is you never told anyone at Tip Top about this alleged bounty on your head and people from Tip Top trying to fulfill it, correct?
But they know about it.
And my question is you never told anyone, right?
No, I never told them.
Okay. And you never told your felony supervisor, Officer Williams, about this alleged bounty on your head that you learned about once you were released from prison, correct?
Yes, my probation officer knows.
So it's your testimony that your probation officer knew that there was a bounty on your head?
Yes.
And is it your testimony that once Mr. Williams found out about the bounty, he did nothing about it?
No.
Judge, this calls for speculation. I'm gonna object here.
Okay, rephrasing?
Did you have a conversation with Mr. Williams about this bounty on your head?
I didn't know the amount it was, but I told him that people was out to kill me.
Okay. And is it your testimony that once you told Officer Williams that he did nothing about it or to help you with this belief that you had a bounty on your head?
No, he just told me stay out of trouble.
All right. But it's your testimony here today, you have no idea who put that bounty on your head.
I got some inkling knowledge of who did it.
Just have assumptions about who put a bounty on your head, right?
I knew I was a robber of drug dealers, and since I've been gone, a lot of guys them came up on a lot of money in life, and they living well, and they got 50,000 to throw away.
Nothing further.
Ms. Wood, do you have any redirect?
No, Your Honor.
Jurors, do you have questions for Mr. Mosley? Thank you. You. That's not a question. That's artwork. All right, Mr. Mosley, you're going to stay right there. Deputy Gordon, you'll stay right here. Lawyers, you can talk with you for a while.
Yes. Great.
All right, Mr. Mosley, few more questions, and we'll see if the lawyers have any follow-up. Let me just get them organized here. Let's start with the bounty. Can you please tell the jury as concisely as you can what the bounty was for? What is your understanding as to why someone, not who did it, but why was there a bounty for you as opposed to this guy or that guy?
Because the bounty was for me because one of the guys that I robbed back in 2012, I kind of shot them also. And they didn't like that at all.
Did you ever report to law enforcement your concerns about, because you mentioned during your testimony that sometimes guys would roll up on you and put a gun to your head, threaten you. This is after you got out of prison. Did you ever report any of that to law enforcement?
Only to my probation officer.
Okay. But not, you didn't call 911, hey, someone just rolled up on me and put a gun to my head. Why not?
Because at the time I didn't know the guys, and by the time I would have called the police, they would have been gone already. They was gone already.
Okay.
So it was just sending them, telling the police something. I don't know, they wouldn't be able to do anything about it.
You mentioned that some of your coworkers at Tip Top were aware of this bounty and maybe harassed you about that some. Did you ever report that harassment to supervisors at Tip Top?
No, I didn't. Even when I got attacked on the job, I tried to fill out a report and they convinced me that that was the wrong thing to do. So I just got medical treatment and just brushed it under the rug.
When you say they convinced you it was the wrong thing to do, the people who attacked you or the Tip Top managers?
Yeah, the supervisor. It's like when I was when I was telling him about the incident, the supervisor was there with a couple of my coworkers also. So it would have been they finding out at the same time that I'm telling the supervisor, and the word could have spread it that it probably would have said that, oh, he a snitch or anything. And I would be stuck out there in the wind, but no help at all still.
You just mentioned that you were attacked once at Tip Top. Was that by Mr. Mathis?
No, it wasn't.
When you were sitting on the bench next to Mr. Mathis the night he was shot, were you sitting to his right so you could reach out with your left hand and touch him? Or were you sitting to his left so you could reach out with your right hand and touch him?
I was he was to my right.
He was to your right?
Yes.
Okay. So if I was behind you two looking at you, you could reach out with your right arm, and I don't know if he was that close, but you would be reaching out your right arm to touch him. Okay. You talked a little bit about 10,000 in cash. Were you carrying that money the night Mr. Mathis got shot?
No, I was not. I didn't even have it saved up all the way.
You were hoping to save up $10,000, but whatever you had, whether it was 8 or 5 by that time, you did not have it on you at the bus stop at Art Center that night. If you did not intend to kill Mr. Mathis, why did you shoot him more than once?
Because the first initial shot, I kind of aimed at the objects in his hand or at his arm, and he didn't drop the object or stop waving the object at me. So I shot again, and because he was still in motion, and I didn't know if at any moment he could have pulled the trigger if it was a gun.
When you shot him the second time, did he drop what was in his hands?
I didn't pay attention. I just know he fell at the time. After the second shot, the initial second shot, he fell to the ground, and that's when I grabbed my bag and took off.
Did you ever see Mr. Mathis put back into his bag either of the items you say he was holding?
No, I did not.
Did you tell the jury during your earlier testimony here that you thought that Erica's last name is Menifee?
That's correct.
Ms. Menifee, that she was involved with someone else at Tip Top?
You said, did I tell her?
I don't remember your testimony. The question is, why did you believe that Ms. Menifee was involved with someone else at Tip Top? But I just wanted to first establish that that's what you said.
That's what I use. I use to accuse her of that. And that's because when the guys make the joke on the job, they might say like $50,000 look real good right about now. But they might say the second part of the joke, they might be like, but I'd rather have sex with this girl. Or they say the F word. They say, I'd rather have sex with this girl other than that.
Meaning your girlfriend, meaning Ms. Menifee?
Yes.
Okay. When you were having the conversation with Detective Steidel, one of the questions he asked you before you got into Ms. Menifee or what happened at Art Center was, have you gone to school? Can you speak English? All that kind of stuff. And one of them was, are you under the influence of anything? And your answer was, not today, not right now. The question is, if we rewind to August 11th, the day Mr. Mathis was shot at the Art Center station, were you under the influence of alcohol or any illegal substance?
Yes, I kind of smoked some marijuana earlier that day after I left church.
You say kinda as in the marijuana was near you or you smoked the marijuana?
I smoked the marijuana.
Okay, 1 blunt, 100 blunts?
Yes, ma'am.
1 blunt. And 1 minute before your long bus and train ride or a couple hours before?
2 hours.
Okay,
More than 5 hours before.
more than 5 hours before. Okay. Ms. Wood, do you have other questions for Mr. Mosley based on those questions?
I do not, Judge, thank you.
Mr. Abadi?
No, Your Honor.
All right. We're done with Mr. Mosley. Ms. Wood, are you calling any other witnesses?
No, Your Honor.
The defense rests?
Yes, Judge.
All right. Mr. Abadi, are you putting up any rebuttal?
No, Your Honor.
All right. Ladies and gentlemen, we have reached the point where the evidence is closed. What remains is closing arguments or summations from the lawyers, and then my charge to you. We're going to take a quick break so the lawyers can get set up. They often have PowerPoints. They want to get the screens adjusted, et cetera. Plus, it's a natural time in the afternoon to take a break. When you come back out here, Mr. Rao or Mr. Abate will give the first part of the state summation. As I mentioned, they get to go first and last because they have the burden of proof. Then we'll see if the defense wants to give a closing. No obligation to give one, but I bet they will. And then we'll hear the rest of the states, and then we'll see what time it is. If I'll give you your charge then, or if that'll be first thing tomorrow morning, and then you'll begin your deliberations. So even though the record is complete and the evidence is closed, it's not time for deliberations. During your break, do something other than talk about the case. Feel free to fan out down the hallway, and we'll get you back in here in 7-8 minutes, unless you do your usual, which is make Deputy Gordon spend about 10 minutes corralling you all to get you back in here. Okay?
All right, the jurors.
1 second, Mr. Mosley.
Right.
Oh, hold on. You had a question?
Yes, I would like to apologize to the family if it's okay.
There will be a time for that, not right now. Okay?
I got kicked off because of the network, but I'm about to.
All right, if everyone could take a seat. We need to do 2 things. One is that, and 2, nice pile of stuff up front, Mr. Mate. The jury charge. I'm assuming based on your client's testimony, Ms. Wood, you are renewing your request for justification to be in the charge.
That's correct.
Okay. Mr. Rouse left, so you'll have to field this one. I think based on Mr. Mosley's testimony, there is sufficient evidence, which is slight evidence, for the jury to be instructed on justification. You agree? Okay. I need to revise the jury charge to reflect that. Does either side need to see that specific language before you do your closings? You are free to talk about it. I'm not gonna do anything that strays from the basics, but what was in the draft that you received wasn't fine-tuned yet to this case. So are you good to go with your closing?
Yes.
Okay, and with at least the first part of your closing?
Yes, the amount of the state's only request would be fine. Obviously, I wasn't, I didn't have a preview of what was gonna be said, today. When the defendant testified, I don't remember the number for the charge, but there's a charge about words alone enough or not enough to excite, all the things.
Sure.
To a reasonable person, so I requested, things of that nature be included in the justification. I think that's 3.1610.
Great, thank you for that. 3.16.10. Okay, I think that's appropriate. My guess is that we'll stop today when the closings are done. So we'll have as a group one last chance to bless the final charge that the jury will get. But I'll work on that while you guys are doing your thing. Is 5 minutes enough time for you to tee up the first part of the state's closing?
I get 10 minutes.
How about 7?
That works.
All right, see you in 7. I will mute things here. Just get the audio back on. Ms. Rivers, are you ready? Mr. Rao, are you ready?
Yes.
We'll get Mr. Mosley. All right, Mr. Mosley is back in the courtroom. We are ready for closing arguments.
What? What? Close the door.
I'm going to address a brief security breach. There we go. The doors around here are, I mean, our door's not working, that door, eesh. Then let's bring the jurors in, please. And I will make as court's exhibit number 1, the 80 note cards that reflect all the juror questions, those that were asked and not asked, so they can be made part of the record. And there are questions on only one side of the card. Can I give that to you now? There you go. That's a big pile.
All right, for the juror. You as the president accounted for.
Thank you, Deputy Gordon. Everyone can be seated. So we are set to start the closing arguments. A reminder that nothing the lawyers tell you for either side is evidence. The lawyers are now going to share with you what they think the evidence has proven or failed to show. They are going to seek to persuade you to decide the case in one direction or the other. And you should feel free to be so persuaded, but know that you are the fact finders and that the evidence comes from the testimony of the witnesses, the physical items, that backpack, photos, etc., and then that one stipulation. That's the evidence, not what the lawyers tell you. With that, Mr. Rao, when you're ready.
Good afternoon, ladies and gentlemen. We're now here at the close of this case. All the evidence has been presented to you in the course of this trial. And so now I'm going to have the opportunity to go further, and my opportunity is going to be really talking to you about the legal principles in the charge that will be applicable in this case. The defense will have an opportunity to then come speak before you and make their arguments, and then Mr. Body will conclude the state's portion of the closing arguments. So what I'm here to do at this particular time is kind of talk to you again about the legal principles and the charges. So Judge McBurney, during the beginning of the trial, read the indictment to all of you, and there's 9 counts in this indictment, 1 count of malice murder, 3 counts of felony murder, each predicated on a specific felony. Count 2, felony murder, is predicated on aggravated assault with a deadly weapon, as alleged in count 5. And counts 3 and 4, felony murders, are predicated on counts 7 and 8, which are separate and distinct from each other as it relates to the defendant being a convicted felon at the time that he possessed the firearm and shot and killed Marco Adams. Then we have count 5, the aggravated assault, count 6, possession of a firearm during the commission of a felony, and counts 7, 8, and 9, possession of a firearm by a convicted felon, which are separate and distinct from each other. And we'll talk a little bit about why it is that there are 3 separate charges of possession of a firearm by a convicted felon as we go through the elements of each specific charge. And so those are the 9 charges that we have to prove. And the burden of proof that we have as a state is beyond a reasonable doubt.
Now, all of you who have watched courtroom dramas or read legal fiction have probably all heard that phrase and have an understanding based on what you see and what you read as to what it is. So a lot of times people don't actually know or are able to conceptualize what it is in the context of an actual courtroom proceeding. And so my job now is going to be to define that for you as you'll also receive instructions from the judges as to what beyond reasonable doubt is. The way I like to start off is to specifically tell you what it's not. It's not going to be beyond all doubt. It's not going to be a vague or arbitrary doubt. And certainly not going to be doubt beyond the mathematical certainty, which is I'm 70% sure, or I'm 40% sure, or I'm 30% sure. It's really just a doubt that is reasonable. And so legally, what it's defined as is the doubt of a fair-minded, impartial juror honestly seeking the truth. Not seeking doubt, but seeking the truth as to what the logical conclusion is as it relates to what the evidence shows and what it means as it relates to the defendant's guilt, in this case, whether he's guilty or not. Now, if there is doubt, it must be based on common sense or reason. Within the context of beyond a reasonable doubt and the state's burden, the doubt has to be based on common sense and reason. It's not just any doubt or a doubt for the sake of having doubt. It's one that's generated from common sense and logical deduction from the evidence presented to you. It's what the logical outcome is from the evidence presented. Look at what has been presented and see where it takes you as far as its most logical conclusion and its most reasonable conclusion. What a reasonable person would deduce from the context of the evidence. That is what reasonable doubt is. And so one way I like to really conceptualize it for jurors is also to distinguish the difference between what is possible and what is reasonable. So we've all heard the phrase, anything is possible, right? That is not the standard in a criminal trial. It is not what is possible, it is what is reasonable. Because the truth is, anything is possible. But what is reasonable is the context in which we have to determine what is the most logical conclusion in this particular case. And so, for instance, to give an example, it's kind of almost a silly example, but I think it drives a point home. All of us go to the grocery store at one point in time. And if you're someone that likes to pick out cereal as part of your grocery items list, you go to the aisle where they sell grocery or sell cereal. And for instance, if you like Honey Bunches of Oats, right, you go to that specific section of the aisle and you pick out the box of Honey Bunches of Oats. And you know it's Honey Bunches of Oats because it's what's designated on the box, but you don't actually see what's inside, right? It's not a translucent box. It's just a box that says Honey Bunches of Oats and has a graphic on there, maybe. But you don't actually see what's inside until you get home and you open the box. You don't do that at the store. You don't go to every single piece of item that you're trying to get from the grocery store that you can't actually see inside to open it up. Just know for a fact that what's inside, you use your common sense and your reason. You don't make a crazy decision to just open up every box in the grocery store and potentially get met by a loss prevention officer or someone in public to say, what are you gonna do? No, you use your common sense and reason. The box or the item is designated as what it is, and then you take it home and you open it. Now, is it possible that the parent company for Honey Bunches of Oats and some mix-up at the factory could have put a different cereal inside? Certainly, the response could be, yeah, anything is possible. But is it reasonable for you at every single point in time that you pick up a box of Honey Bunches of Oats that you have to open it in order to see what's inside? No, you use your common sense, your life experience, and your logical deduction to determine that the box of Honey Bunches of Oats is what it is. And that's kind of the standard here. Is it what the defendant just testified to as to what the most reasonable conclusion is? That he was acting in self-defense? Or is it that, as he indicated to Detective Sato on August 14th, they had no issues with the markup, that the video shows nothing about what he testified to, that he just snapped got up, brandished his gun, and fired at least twice in the direction of DeMarco Mathis, an unarmed man, before fleeing the scene, leaving him to ride in agony as he leaves and goes and hides out in his house. What is the most reasonable conclusion in this case that you can derive from the evidence in this particular case? So in the context of beyond a reasonable doubt and the things that you can and can't consider, there are certain things that the judge is going to instruct you on as far as what not to consider in the context of making your decision. So it's not going to be about passion or sentiment, your like or dislike of the police or public opinions that you might have. Everyone comes in with their own life experiences. No one is telling you to completely discard that. But there's a reason why you all are here, is because you are objective people that can look at the evidence and make a logical deduction as it relates to what that evidence shows. It's not a disagreement with the law. You all took an oath to uphold the law, and the law that the judge provides will be what you have to go and apply to this particular case. It's not going to be about what the consequences of your verdict will be if you all believe that he is guilty beyond a reasonable doubt. It ends there. You don't consider what are the possible consequences of that. That's for the judge to determine what the appropriate remedy is as it relates to your verdict. It's not about prejudice. It's not about sympathy. If you feel sympathy for the defendant, for the life that he's had to live up until the point in time where he pulled the trigger on DeMarco Mathis, that's not really something that's relevant in the course of this particular proceeding. Everyone has their own trials and tribulations in life that they go through. And in the context of the actions that we do in this particular case, the defendant pulling the trigger not just once, but at least twice in the direction of another human being, leading him to die in agony, as we see on that video. Those are the things that we have to look at, not the context of the life that he's had to live. I'm sure he did fall in hard times back in 2012, but he made the decisions that he made. That affected other people. And just like the decision he made to pull out his gun, point it in the direction of DeMarco Mathis, ceasing him to exist by shooting him twice. And it's not going to be about conjecture as to what it is that hasn't been presented to you that you think could show something that doesn't exist. It's about what you see on that video, what people testified to, and the videos and documents presented to you as it relates to what you should consider. So specifically in talking about the things that you can consider, it's going to be the elements of the crime, which I will discuss with you. It's going to be about the law and the legal principles. It's going to be about forensics evidence, like what the GBI expert said, which is that the gun that was found at the defendant's residence in the attic that he was hiding is the murder weapon. It is the gun that was used to kill DeMarco Mathis. It's going to be the photos and documents that we have of the scene, the CAD report, the autopsy report, the GBI ballistics report, the still shots that were used to identify the defendant as the perpetrator in this particular case. And then we consider the defense, and we'll talk a little bit about that towards the conclusion of my portion of this presentation as it relates to the law of justification and self-defense, and how that really applies in this particular case. And the defendant's actions. I mean, he's asking you to believe that he was legally justified in taking the life of someone else, but left the scene and then hid in his attic for 2 days, according to him, even though he didn't actually stay in the attic the whole 2 days, as he would have led you to believe on direct. It's about the actions that he took on the night of August 11th, 2018, or 2024, when he pulled out his gun and shot Mr. Mathis at least twice, causing him to die. When there's uncontroverted evidence, it is uncontroverted that he did not have any of the things that this defendant said that he had on his person. There was no mention of it and no questions asked of the responding officer, of Mr. Thompson, of Officer Williams as it relates to the bounty that Officer Williams supposedly knew about. No questions about that. There was no mention of any quote unquote object that, or objects that the victim allegedly had on his person at the time that the defendant made a decision to point his firearm in the direction of DeMarco Mathis and shooting and killing him. There's no evidence of that other than he wants you to believe that that's true because it's in his best interest. Look at the credibility of the witnesses in this case. For Michael Thompson and Erica Menifee, who really have no reason to say the things that they said other than that's what happened. That Mr. Thompson heard what he heard, saw what he saw, that Ms. Menifee said the Sunday before his arrest, which would have been the day of the incident, when he shot and killed Mr. Mathis and co-worker, that she broke up with him. And that was also one of the days that he accused her of infidelity, specifically with coworkers. The most important asset that you have with you, that you get to take with you when you go back there and deliberate, is your common sense. Who has the reason to say the things that they say and what supports that? Is there anything that supports what the defendant said other than his own words? Versus what is there to support that the defendant was not justified in shooting and killing DeMarco Mathis? And in using your common sense and the law that you'll be given, you'll apply it to the facts and the evidence that's been presented to you in the course of this trial. The evidence has come before you in two separate forms. There's direct evidence and then there's circumstantial evidence. The legal definition of direct evidence is evidence that points immediately and directly to an issue. For instance, Mr. Thompson saying that he observed the two of them being cordial up until the shooting. When he looked back and saw the defendant point the firearm and shoot Mr. Mathis again, after hearing the first shot. Direct evidence is the still shots of the defendant on the Martis events on the day of the homicide. Direct evidence is the fact that the firearm recovered from Mr. Mosley matched the murder weapon that was used to kill Mr. Mathis. That's direct evidence. Circumstantial evidence, as legally defined, is proof of facts or circumstances from which you may infer other related or connected facts that are reasonable and justified in light of your statements. What that means is you take a group of facts, you put them together, and you make a logical inference from that fact. So, the best way that I can describe circumstantial evidence is give you an example of when we all have to go to the gas station to fill our tank. So every now and then, the gauge will be close to empty, and that's our cue. We have to drive a car that isn't electric to go stop at the gas station and fill up the tank. And so when that occasion calls for it, we can go to the gas station, we stop at a specific pump, we get out of the car, we put the credit card or debit card, or we go pay cash at the register. We take the nozzle out of the pump and we put it into the tank of the vehicle and we pull down on the lever. And then we see that the amount of gallons is going from zero and steadily increasing. We see the amount of money that we're paying for it increasing even more. And eventually the nozzle will stop. That's our cue to take it out of the tank, put it back into the pump, close the tank, get in the car, and drive on. And at that point in time, you've not seen gas go into your car, right? Well, what you can logically deduce from a group of related facts is the fact that you know that your gauge was reading empty. You had to stop at a gas station, you filled up the tank, You got in a car and you drove on, and you continue driving, and your car isn't reading empty anymore, it's reading full. And as you continue to drive, even though you did not see gas go into the car, you are able to infer from a group of related facts that gas in fact went into your car at the time that you went to the gas station. So that's kind of what circumstantial evidence is in this case. And in this case, specifically as it relates to examples of direct and circumstantial evidence. Direct evidence is the fact that there's a video where you see the defendant pull his firearm and shoot DeMarco Mathis. You see and have heard Mr. Thompson's observations as it relates to what he saw, that the defendant just shot. There was no reason for that, based on the observations and the things that Mr. Thompson heard, that Mr. Mathis was not acting aggressively, that they were in a cordial conversation. Direct evidence is the shirt, the shoes, the hat, all matching the outfit that the defendant wore on the day of the homicide, being found at the residence that he was hiding at when police came knocking with an arrest warrant for the murder of DeMarco Mathis. And of course, the murder weapon, that is direct evidence in this particular case. But the fact that the weapon used to kill Mr. Mathis was found in defendant's possession. Example of circumstantial evidence would be, say for instance, we did not have the video in this particular case, but we had Mr. Thompson able to give a description of the suspect in this case, which was Falcon's hat, black shirt, black pants, white shoes, and in the defendant's possession are those things in addition to the firearm that ultimately came back as the weapon that was used to kill DeMarco Mathis. From that, even though Mr. Thompson may not necessarily be able to identify the defendant, the fact that he was able to give this description and they found these exact things in Mr. Mosley's residence to include the murder weapon and all circumstantial pieces of evidence that you can use to logically infer that the defendant was the shooter. But the defendant identified himself and the defendant admitted to shooting. And it's not necessarily that his ID is circumstantial in this case. The question is, did he murder Mr. Mathis, or did he act in self-defense, of which there's no credible evidence that has been presented to you during the course of this trial. What's been presented to you has been exhibits through the course of photos, documents, videos, and physical evidence to include the murder weapon, the projectiles recovered from the victim, the shell casings that were recovered from the scene, as well as the items recovered from the defendant's residence, all showing that he was in possession of the articles of clothing that he wore on the day of the homicide. We also have evidence in the form of lay witnesses, like Mr. Thompson and Ms. Bennett, who came before you and testified to the things that they did see and hear and interacted with as it relates to the defendant, and specifically Ms. Menifee's relationship with the defendant and the incident that occurred on August 11th, 2024. Now, as it relates to the testimony of a single witness, the testimony of a single witness, if believed, is sufficient to establish a fact. Now, I will tell you that everything that Mr. Thompson and Ms. Menifee said was uncontroverted by the defendant. There was no questions asked, which means that everything that they said, you can take to the bank in cash. Because Mr. Thompson specifically said that he observed the two of them in a conversation, that there was no hint of aggression from what he saw. And when he turned around and heard the shots, and then turned back around and saw the defendant pointing the gun and shooting it in the direction of Mr. Mathis, that is uncontroverted. It is what happened from an eyewitness who saw it. And there was nothing about Mr. Mathis having a phone or an object that could pass off as a gun mentioned by him. There was nothing. He didn't have it. Nothing that the defendant said that Mr. Mathis had in his hands as he was being shot was presented to you by an objective third-party witness who has no reason to lie or say the things that he said, other than that's what he saw and that's what he heard. Just like Miss Menifee. She even said that she's trying to be on good terms with the defendant. She doubled down on the fact that it was the Sunday before his arrest that she broke up with him, the same day that Mr. Mathis was shot and killed by the defendant. The same day where there were allegations made at Miss Menifee over the fact that she was having an affair with a co-worker of his, of which Mr. Mathis was. Look at the credibility of the witnesses. What does Mr. Thompson's bias or lack thereof in this case? He doesn't have a bias. He literally just told you what he saw and what he heard. What is Miss Menifee's bias or lack thereof? Well, we know that she has had a relationship with the defendant, and she even testified on the stand that they were trying to be on better terms. But even she said that on the day of the murder, they broke up, and there were allegations made about infidelity as it relates to her involvement with a coworker. What corroborates the defendant's version of events as it relates to self-defense, and what corroborates the fact that the defendant acted in malice? Shooting and killing Mr. Mathis and leaving him to die at a MARTA bus. What is the probability of that being the reason why he shot and killed Mr. Mathis versus whatever it is he testified to on the stand? What is the logical conclusion when you take the evidence in its entirety, weigh the credibility, and what is the only logical conclusion? It's not that the defendant acted in self-defense. It's that he took out that gun, pointed it at an unarmed man, shot and killed him. Now, as we go into the elements of each and every offense, I'm going to talk to you a little bit about intent. So intent has to be formed to commit the actual act. It's not about having the intent to commit murder or having the intent to commit aggravated assault. It's the intent to commit the acts that support those charges. So for instance, it's the defendant's intent to pull out the gun from his pocket, point it at the direction of Mr. Mathis, and fire it multiple times. That's the intent that we need to show in order to prove specific intents as it relates to each and every crime in this particular case. And when it's the foreseeable consequence of something, you intend to do it. So when you intend to point a gun at another human being at close range, there's no other foreseeable consequence to a reasonable person other than you're intending to kill him. You're intending to shoot him. You're intending to do it while being a convicted felon, knowing that you're not supposed to be in possession of the firearm. That is the intent. It is the intent to commit the actual acts that support the charge. So as it relates to count one murder, it's legally defined as unlawfully and with malice, afterthought, causing the death of another human being. Now, I want to spend a little bit of time on this because I think, from my experience, jurors have a hard time divorcing what we colloquially refer to as malice as to what is actually legally defined as malice. So when we all think of malice without having the legal context behind it, we all think that it means hatred, that it means ill will, that it means that an individual woke up that particular day and made a decision to kill, and it actually means none of that. It means that at the time that you did the act, you had the intention to kill without justification, without provocation, and without any sort of legal excuse to do so. So that is the malice in which you all have to find the defendant guilty of as it relates to count one murder. It is not the intent that Mr. Mosley, the defendant, intended to, or hated the victim. It's the fact that he simply intended to point the gun at the victim and shoot him multiple times, killing him. That's the intent. It's the intent to kill without justification. Because when you point a gun at someone at the range that the defendant was at in relation to Mr. Mathis, the only foreseeable, reasonable consequence of that act, when you discharge that firearm at least twice in the direction of another human being, is that you're going to kill them. And that is the malice that is required as it relates to count one. It's going to be defined to you in two different ways: express malice and implied malice. It's a lot of legal jargon that I don't know why they've written the charge the way that they have, but it's legally defined as deliberate intention to unlawfully take away the life of another human being shown by external circumstances capable of proof. That is how express malice is defined as, and implied malice is defined as when no considerable provocation appears, when all the circumstances of the killing show an abandoned and malignant heart. It's ultimately for you, ladies and gentlemen, as fact finders, to determine whether or not the defendant acted with malice at the time that he brandished a firearm, pointed it in the direction of another human being, and shot him at least twice. So that's the two types of malice that you have before you that you can consider as it relates to whether or not there was malice in this case. So that's the legal jargon that you decided on as it relates to how to define that. How I like to distill it down for most people who aren't writing a bunch of legal jargon is express malice is actions that are deliberate. It is deliberately taking your gun out, pointing it at another human being, and pulling the trigger, not just once, but at least twice, without any justifiable provocation. Justifiable provocation. Implied malice are actions that imply the willingness to hurt somebody. And oftentimes the acts that constitute express or implied malice are often the same. So for instance, in this case, the fact that the defendant intentionally pulled out a gun and pointed it and shot another human being is indicative of express malice. But implied malice is also when you shoot an unarmed person with no weapons, no knife, no nothing in his hands at the time that he's shot, and leaving him to suffer as he dies while you casually take your backpack and saunter off to the MARTA train is indicative of implied malice. Neither case, whether expressed or implied, malice just means that the killing was unjustified under the applicable law in this particular case. The defendant's actions in this particular case show a disregard for human life. He carried a weapon when he wasn't supposed to, pulled it out, pointed it in the direction of another human being, and shot him. Again, as I stated before, premeditation is not required. So he didn't have to wake up that morning or even head off to the bus thinking that I'm going to kill DeMarco Mathis. The premeditation is not required. The malice required to form the intent behind malice murder can be formed at its meaning as soon as the defendant decides to pull out his firearm, decides to point the firearm, decides to pull the triggers when that malice can be generated in his mind to kill another human being. Now, as it relates to counts 2, 3, and 4, felony murder, it doesn't require an intent to kill. There's no express or implied malice that is a predicate for this particular charge. Doesn't even require that you intend to kill. It just means that you committed a felony. And during the course of that felony, there's a logical connection and causal connection between the predicate felony act that you performed and the death of another. And in this particular case, he's charged with 3 counts of felony murder. Count 1, count 5, aggravated assault for shooting Mr. Mathis. Count 2 for being a convicted felon I'm sorry, count 7 for being a convicted felon while in possession of a firearm on August 11th, 2024. And then again on count 8 for being in possession of a firearm by a convicted felon for a separate conviction. Both of those are sufficient to show that there is a causal connection between the fact that he was a convicted felon in possession of a firearm, that firearm that he used while being a convicted felon resulted in the death of another. So the fact that even if he didn't intend to kill, the fact that he killed somebody while being a convicted felon with a firearm that he is accused of possessing for those predicate counts is the causal connection between the act of being in possession of a firearm by a convicted felon and the death of another. So as it relates to those predicate felonies, aggravated assault is an assault with a deadly weapon, which as a matter of law, a firearm and handgun is considered a deadly weapon, is used to assault someone. And by assaulting, I don't mean actually causing injury, because actual injury isn't required, although in this particular case, we saw the autopsy photos of Mr. Mathis's wounds to his torso as well as to his right arm. We know, in fact, there was, in fact, violent injury in this particular case. Mr. Mathis's gunshot wounds and the fact that he was assaulted by the defendant while he was in possession of a deadly weapon, a firearm, is sufficient to support the facts of count 5, aggravated assault. Count 6 is simply just that, possession of a firearm during the commission of a felony, which is that you are, during the commission of a felony, possessing a firearm. In this particular case, we've enumerated 3 felonies: murder, felony murder, and aggravated assault. So the fact that he was in possession of a firearm during the commission of at least one of the following felonies is sufficient in order for him to be found guilty on count 6, possession of a firearm during the commission of a felony. Count 7, the fact that he had been previously convicted on January 22nd, 2014, under indictment number 13 SC 118174 on August 11th. The fact that he carried the weapon with him on the MARTA bus, the fact that he had the weapon on him on the train, the fact that he had the weapon with him on the platform, the fact that he had the weapon on him when he shot and killed DeMarco Mathis, and the fact that he took that weapon with him to back down the steps to the train, to the bus, to wherever it is he got off that day on August 11th is sufficient. Any one of those acts is sufficient. The fact that he carried the firearm to the scene where he killed Mr. Mathis is sufficient to convict him on this charge alone. The fact that he possessed a firearm on that day, August 11th, is sufficient to convict him on that charge alone. On count 8, possession of a firearm by a convicted felon during the commission of a felony involving the person of another. In this particular case, the fact that the defendant was a convicted felon, having been convicted under 12 SC 115756, a separate and distinct felony conviction from the previous count, and the fact that that count involved a particular qualifying charge that then supported this particular charge because he used this firearm against another human being while having been convicted of armed robbery on 12 SC 115756. The fact that he was convicted of that specific offense is what qualifies and triggers count 8. And the fact that he used it against another individual shows that he is guilty on count 8, possession of a firearm by a convicted felon. On count 9, possession of a firearm by a convicted felon. It is very similar to count 7 in the sense that he possessed a firearm, at least on this date, it was August 14th, because that was the day he was arrested, and a firearm was found in the attic where he was hiding in a blue box that ultimately came back to the weapon that was used by him on August 11th. That is sufficient to convict him on this charge. The fact that he was found in possession of a firearm on August 14th, 3 days after he murdered DeMarco Mathis, is sufficient to convict him on count 9. Now, based on the credibility of the defendant's testimony self-defense doesn't really apply. Because nothing that he testified to actually happened the way he testified to it. But as it relates to the law on self-defense, it's in instruction, since it's one of the defendant's defenses in this particular case, I'm going to tell you a little bit about the law as it relates to self-defense. And what self-defense and justification says is that you are justified in using deadly force to use it to cause the death or serious bodily injury of another under the following circumstances. You believe that the use of such force is necessary to prevent your own death. That you reasonably believe that pulling out a firearm and pointing it at another person and discharging that firearm in the direction of that person is reasonably necessary in order to prevent your own death and serious bodily harm. Or to the third person, but there's no facts or evidence to support that he was, in his own words, trying to defend anyone but himself. And again, the facts and the credibility of what he testified to has to be taken into consideration as to why he has the reason to say the things that he did on the stand versus everyone else. A person is not justified in using force. That person is committing a felony or the initial aggressor in this particular case. And there is a caveat to the law that says that, the initial aggressor can withdraw and then subsequently can become justified in their actions using deadly force, but only if they clearly communicate that intent to the other individual that they're withdrawing themselves as the initial aggressor. And that person then continues to threaten the quote-unquote initial aggressor. At that point in time, the initial aggressor can use deadly force. It's not really applicable in this particular case, but it is something that you will be instructed on as it relates to the law on justification and self-defense. Now, the concept of excessive force is that even if you are defending yourself, if you use more force than what is actually reasonably necessary to protect yourself, you are not justified in defending yourself. The actions that you take in that particular instance is considered to be excessive, and despite whatever reasoning you give for why it is you did what you did to quote-unquote defend yourself, you no longer enjoy the umbrella of justification and self-defense. In this particular case, the defendant shot Mr. Mathis not just once, but at least twice. And at no point in time was there any objects in his hand such that the defendant could have thought that he was defending himself, such that the defendant reasonably could have thought that he needed to discharge his firearm twice at another human being. Shooting an unarmed man is excessive in every which way possible you can conceive. And there has been no evidence other than the defendant's own self-serving testimony as it relates to what transpired on the night of August 11th, 2021. The defendant has to be reasonable in applying the force that results in the death or serious bodily injury of another. That a reasonable person in the defendant's position would have thought that the only action, only course of threat at that particular time would be the use of said deadly force in order to protect himself. It is the reasonableness behind that belief that justifies the act, the reasonableness. Now, you're also going to be read the charge that words or threats in and of itself, unaccompanied by nothing else other than words, is not sufficient for the authorization and use of deadly force. So if I tell Mr. Abadi, I want to kill him, the fact that I say that does not then allow him to brandish a firearm in my direction and shoot me. The fact that I make any threats just by words alone is not sufficient to justify anybody in using deadly force. And only when verbal threats are accompanied by menacing actions could it justify the use of deadly force. The defendant said, and we'll get to a little bit about his statement and the credibility thereof, that at first the victim flashed something in his book bag on direct, and then switched it up and started adding things on cross-examination with Mr. Body, where he then made mention of this object in his hand and the cell phone that the victim was allegedly using to cover up the quote-unquote object that he didn't know was or wasn't a gun, and attempted to threaten the defendant. That was not something that he voluntarily put forth in his direct examination when describing the offense. In fact, that is a whole other thing that he added on cross. At first, he said that they were just sitting on the bench and he just shows him an object in his book bag, and it was so fast, it was like a flash. He didn't even know what it was. And then it transformed on cross to, yeah, the victim, just before I shot him, had this thing in his hand and he was covering up his cell phone. None of that happened. And even assuming that, according to his version of events on direct examination, that the victim showed him something in his bag does not in and of itself, then later on when the victim says, I'm gonna bribe you, or have you ever been shot, whatever it is that he said, does not then justify the death of another human being. That's not even what happened, because it doesn't make sense. And the fact that he continued to add on to things during his cross-examination, as opposed to being voluntarily upfront about it on direct, when he had an opportunity and was given that opportunity to describe in detail what actually happened that led up to the events, there was no mention of this object in his hand, that he was pointing it in the direction of Mr. Mathis, or excuse me, Mr. Mosley. There was none. And so a lot of what he testified to is unreasonable when taken at its word, with no other evidence to corroborate. The first, he testifies that there was a $50,000 bounty on his head that everyone magically knew about it. And that supervisors at a chicken plant decided that they wanted to cover it up and not go forward with a complaint. Well, we had the person that would have been in receipt of the complaints. There was no mention of any $50,000 bounty that he was aware of. There was no mention by the probation officer about the $50,000 bounty that the defendant testified that he was aware of. There was nothing like that. So the idea that everyone at the chicken plant knew about this bounty and that anybody could be collecting on it is unreasonable. The fact that the defendant testified that DeMarco Mathis took something from his backpack and presented it as a gun, which he did not testify to on direct, which is important because that is his opportunity to tell you. He doesn't have to add on to stuff on cross-examination, but he did. He says that the victim took something out of his backpack and presented it as a gun, even though there's uncontroverted evidence that no one manipulated the scene after the shooting and that the backpack was zipped up when officers arrived on scene. So you're saying that the victim took something out of his bag, presented it as a firearm, and then zipped up the bag? Like he has enough time to think about doing all that if he's trying to rob this guy? Does that make sense? Is that reasonable? Or does it fall under the category of unreasonable and not credible? The defendant testified that the reason he ran away is because he just shot and killed somebody and he didn't want to be caught by the police because he didn't know what they were going to do to him, right? He was afraid of that. But he's not afraid of this dude that is allegedly flashing weapons in front of him and he's just sitting side by side with him on a bench, not moving. Does that make any sense? I mean, he said he was cautious at that point. He didn't shoot him as soon as he said, hey, have you ever been shot? Or what if somebody robs you? He said he was overly cautious, but he didn't get, he wasn't concerned enough to run away. He was only concerned enough when he shot and killed somebody. Does that make any sense? That during this encounter, during this conversation, despite feeling uneasy, that he wouldn't just get up and go to the other bench and say, I'm done with you? He would just continue sitting there, and the only reason why he would flee is he shoots somebody? Not because someone was threatening him, but because he shot somebody, and of course, police are gonna get involved every time you shoot somebody. That's what leads him to flee, not the fact that he's quote unquote, in his mind, in his words, being threatened. The defendant said that the victim was pointing an object. Well, we never saw that object on scene, and more importantly, he never pointed it out. Because it doesn't exist. There's crime scene photos. There's body camera footage. There's all this stuff that we saw. He had an opportunity to point it out, but he couldn't. He couldn't even describe what the object was. All he said was that it was in the victim's hands and that it fell out after he shot. Where did we see that in any of the crime scene photos, in any of the body camera footage, in any of the surveillance video? And in fact, let's look at the surveillance video. Let's look at the point in time when Mr. Mathis was being shot. Where do you see anything fall out of his hands? He said that he had it in his hands, both hands. Where do you see anything fall out of his hands? It's because what he testified to did not happen the way he wants you to believe it. It happened exactly as how it's depicted on that surveillance video. He got up, he pointed the gun, and he shot an unarmed man. He never seems to be cooperating. But I'm coming at the conclusion. What I can say is this, ladies and gentlemen, you've had all the evidence. You'll be given the applicable law. In this particular case, there is no evidence to suggest anything of what the defendant said was in fact credible and or true. There is every bit of evidence to suggest that this was a callous, reckless, deliberate act where he pointed a gun at an unarmed person and shot him multiple times. And the state respectfully asks that you, ladies and gentlemen, hold him accountable for that by finding him guilty of each and every count in the indictment. Thank you.
Thank you, Mr. Rao. Ms. Wood?
Judge, I just want to make sure, is the Zoom gonna keep playing at 5 o'clock?
Let's find out. I don't know. Ms. Nelson, do you know, will we make it past 5 o'clock on our Zoom? We're not staying super late tonight, but they don't want the feed to stop up at
Yes.
5.
Yes, it'll keep going, Judge. It'll be ended by the host.
Great.
Perfect.
So as long as you don't end it, Ms. Wood, we're good.
Try not to. Oh, there's a delay, I forgot. I stood up here on Tuesday and I told you all that this is a case about Xavier Mosley making a decision to defend himself. And I stand on that today. The state has not proven to you otherwise. This is not a case about what's on that video. It's a case about what's missing. What you don't see, what you don't hear in that video. Missing audio, the giant column that is obstructing the view, the lack of eyewitnesses, even though we know there was at least one there in the bus loop who actually saw what was happening. The state of Georgia, the government, thinks they've got this case all figured out. But the truth of the matter is, they weren't there, neither were you. This case hinges on everything the state of Georgia, the government, cannot prove here. And if they don't prove this case beyond a reasonable doubt, you must acquit Xavier in this case. Now, Mr. Bell got up here and started off talking about the state's burden. And I always find it interesting when the state wants to tell you about what they don't have to prove in this case, right? So I think you all can see this well, but I'll just walk you through. This is a chart that shows the levels of proof, okay? So down here at the bottom of the staircase, we've got no evidence, no trace whatsoever of anything. So that's, of course, a not guilty, right? And if you go up a few steps, you get your reasonable suspicion. That's all it takes in the state of Georgia for an officer to stop you and frisk you and start an investigation. It's not based on a hunch or a guess. It has to be based on something specific, something in particular, right? Still, that's not guilty. One step above gets us to probable cause. That's all an officer needs to arrest someone. It's got to have something for that, right? But it's still not guilty. It's not enough proof. Traveling on up the staircase, ponderance. That is the greater weight or amount of evidence. That's all you need to win a personal injury auto collision case, right? But in this situation, still not enough. Still would have to be a not guilty. And if you go up one more step, you get to clear and convincing evidence. That's a belief that the allegations are true. That's all the state of Georgia needs to take away your child. But in this situation, still not enough. Still not guilty. And here at the very top of the staircase is beyond a reasonable doubt. That is the highest burden in all the land. And the state has to prove each and every element of this case beyond a reasonable doubt. Now, Mr. Rao talked to you about a box of cereal at Publix or at the grocery store. And he used this example of you're buying honey bunches of oats and, you know, basically it's the idea that, you know, that's going to be honey bunches of oats in there when you purchase it. But you don't actually know that until you get home and you open up the bag. You don't know if it's going to be contaminated, if there's a dead bug in there. That happens, right? You don't know that for a fact when you're buying that box of cereal until you get to the house and open the bag up. Now, again, I just said a little bit about reasonable doubt, and I'm going to talk about that for a minute. So you would be authorized to find Xavier guilty only if the evidence, whether direct, circumstantial, or both, excludes each and every reasonable theory of innocence and proves the guilt of Xavier beyond a reasonable doubt. Now, I want to talk to you about some examples of reasonable doubt in this case. The reasons to doubt the state's case in this scenario. I want to start with the investigation. It is tearing the state up that I told you all about that knife in the backpack. Mr. Rapp stood before you and said multiple times DeMarco Mathis was unarmed, and that is a bold-faced lie. He had a knife in his backpack And you all would not have known about that, but for me bringing that up. The state does not want you to know that there was a deadly weapon in his backpack. They don't want you to know that. What else do they not want y'all to know? Detective Stidle, lead investigator, never bothered to actually do a full investigation here. Never bothered to take himself up to Marietta, Georgia, not that far away, talk to coworkers. Maybe he would have learned about the bounty on Xavier's head if he had taken the time to do that, but he didn't. Because he saw the video, the surveillance. We got him, call it a day. That's all they did. No investigation into the why. Nothing. Never talked to friends and family of Xavier outside of Erica. Never spoke to Mr. Mathis's friends and family to see if there was anything else to flesh out there as part of the investigation. Didn't bother. No fingerprints were taken. The crime scene technician didn't even go to the actual scene of the shooting. I mean, that's suspect. That's just, the math is not mathing here. And again, that video, everything that happened leading up to this incident is obstructed by that column. And you all will get to watch that video again. I'm sure because, Mr. Rao just played it really quickly right then. You all can watch it again and see for yourself. There's a huge column obstructed the view. So we don't actually see everything that goes down. And then that reminds me, was there any other surveillance footage, a different angle at Marta that Detective Stidle didn't bother to get? We don't know. And if you decide to review the video, please pay close attention. Because the state, one of their witnesses wants you to believe that Xavier not only fired, but then turned around and stood over the body again and fired again. That is not on the video. And again, I told you on Tuesday, we can't hear anything on the video. Xavier bravely got on the stand and told you his truth, that he felt threatened, that he was scared for his life. But we actually cannot say for certain what actually happened because there's no audio. We weren't there, ladies and gentlemen. Now, I want to walk you through the state's witnesses. Witnesses who did not witness a thing. We started off with Miss Littles. She was a nice lady. She's not a cop, but she had fun playing one for this trial. She didn't witness anything. She also told us that she saw someone standing across from the bus loop, but she didn't bother to get a name or contact information or to follow up and, maybe, hey, Detective Stidle, reach out to this person, see if they actually saw or heard anything. She didn't do any of that. You would think if a shooting just happened, that would be important, right? But she didn't do it. Then we had Mr. Thompson, the bus driver from Cobb County, nice guy. But his story doesn't actually add up with what we actually see on the video. And he also told us he was busy making sure he had passengers on his bus. So he wasn't fully engaged in observing what was happening. Sure, he told us they seemed calm and just chatting, but he wasn't focused on the two strangers sitting on the bench. He had passengers he was getting ready to pull off. He even had his back turned, he said, at the time of the incident. He literally told us on the stand that he saw Xavier stand over DeMarco, and that is simply not on the video. He also told us that he stood around and waited for the police, but then he had no recollection of his interaction with the police officers. Again, no one bothered to check with the eyewitness across from the buster. Why? Why not? Okay, so now I'll talk about the actual law enforcement witnesses and their investigation lack thereof. Officer Marthone, first officer on the scene, also a witness who didn't witness anything. Again, no testimony, he even, I don't even think he cased the area to see if there was a suspect or if he did, he didn't find anyone, but also didn't bother to check with eyewitnesses. And when you watch, if you just decide to watch the video again, you'll see there were other people milling about as well. It's a MARTA station, it's in a busy part of town. Did anybody bother to check by eyewitnesses? It sure doesn't seem like it. Sergeant Pullen, same thing. I find it interesting. The state wants to make a big deal about Mr. Bruce not knowing anything about DeMarco and Xavier. He's the boss. Did he look like a man that's gonna go to his chicken plant at midnight and talk to the guys who are cleaning up chicken guts? I don't think so. Of course he doesn't know. You think there wasn't people that actually worked with DeMarco and Xavier that could have actually told the detectives a little bit? Probably. But did they do that? No. Because again, they had this surveillance, so we got him, that's all we need to know. And they stopped there. Detective 3 was sent to Tip Top, but again, did not bother to speak with anyone that worked in the sanitation department, didn't bother to speak to anyone who may have known anything about Xavier or anything about DeMarco. And then we had investigator Berhalter, nice guy. He was on the scene at the Jernigan Drive address. So what he knows about the actual incident was limited. But he kept mentioning this other detective. State never put that person on the stand. So again, what was the point of having investigator Berhalter brought in? I do not know. We had another detective. Didn't know very much, he was just on the scene, didn't check to see who the firearm belonged to, did not even search the backpack. Again, not sure why that person was brought in. And then we heard from crime scene tech Nelson, who you would think, or at least I would think, that for a murder investigation, you would want to send your crime scene tech to the actual place where the shooting happened. Why not? Why wouldn't you send her there? Didn't go to the actual scene. No DNA swabs, no fingerprints. Couldn't even tell us if a .380 could fire a 9mm round. That's an officer. That is a law enforcement officer. And then we get to Detective Stidle. This was his second murder investigation. Only been a detective for about 5 months. Everybody's got to start somewhere. He was only called to that scene because the detective on duty was busy elsewhere. And you all, great questions, by the way. One of your questions, he ended up telling us in the course of answering your questions that his report is actually inaccurate. What else is inaccurate if not the time is wrong? What else is wrong in his report? He couldn't even remember the names of the people he spoke to, and I also messed up because he said Consuela, so I said Consuela. It was actually Donald West. He didn't actually investigate anything. He told us key parts of a murder investigation were farmed out to other detectives. And then the state didn't even bother to bring those detectives in. By the way, I'm gonna get ahead of this because Mr. Biden might try to make a big deal out of it. The state may try to say Ms. Wood could have subpoenaed those detectives. The answer is why would I? Because I don't have to prove this case, they do. Ladies and gentlemen. Detective Stiles should be ashamed of himself. He got up here on this witness stand for a murder case and told you he didn't bother to go to Tip Top. He didn't bother to speak to family members. He didn't bother to check for additional CCTV footage. For all we know, Marta's got another camera facing the side that's not reflected by the column. Who knows? We don't know because he didn't do it. How can we trust the government's assessment of what happened here when their lead detective told you his report is inaccurate? It's not good enough. This is a murder case. That's not good enough. Detective Stile was not going to tell you all about that knife. The knife found on DeMarco Mathis's person. That is a deadly weapon, ladies and gentlemen. That is a deadly weapon. He told us with a straight face he could lose his job for mishandling evidence. And he wasn't going to tell us about a black knife. He couldn't even recall the size, the shape. Was it a hunting knife? Was it a pocket knife? Was it a machete? We don't know. Was it photographed? No. Was it processed in? No. Thank God he put it on a piece of paper. Otherwise, we wouldn't even know about it. The buck should have stopped with Detective Stile. And they say the fish rots from the head while this investigation reeks. Again, we would not even know about this if we had not put it up here. Plain as day, first item on his description of property and evidence, black knife. It's kind of important, don't you think? For a murder investigation, another deadly weapon is found not only at the scene, but in the decedent's property. In his backpack. You may be asking yourself, why? Why didn't Detective Stile make a big deal about this? Why didn't the state make a big deal about it? It's because they didn't want you to know about it. Well, we cleared this up because Xavier got on the stand and told you his truth. But no one with Marta Police Department or Atlanta Police Department or any other of the, line of law enforcement that we saw, no one bothered to figure out where did the gun come from. And again, this is a murder case. It's kind of important. Now, the judge is going to give you the law. And it's going to say, I think this is the pattern charge that we put on here. So sometimes the defendant's use of force is legally justified. Therefore, it's not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when he reasonably believes that the use of such force is necessary to prevent death or serious bodily injury to himself. Xavier did not have to get on the stand. We, the defense, have no burden. Y'all may have thought that I wasn't gonna do anything because that first day I was not asking any questions and that would have been completely fine. Because I don't have to do anything. The burden lies with the government, okay? But Xavier wanted you all to know his truth. The story of what happened, and sure, he was nervous. I would be nervous too if I had to sit in front of strangers and let out-of-body cross-examine me. But he got up here and he bravely told you his story. He told you about his past, about the mistakes that he's made. Okay, he told you that. We're not trying to hide that. I told you at the beginning of this trial, he's got a past. Please don't be distracted by that. Got on the stand, told you about his past, told you about his life at the time of this incident. That's not easy with strangers to be that vulnerable. Wasn't an easy life. I have to travel almost 3 hours just to get to a chicken plant to clean up chicken guts overnight. And then I have to travel 3 hours again back to your residence. But he told you about his life and what happened that day, because he wanted you all to know the truth, that he genuinely feared for his life. He truly felt that he was about to be in harm's way. And Mr. Abadi made the point, you could have gotten up and you could have left, and everything else he said. But Xavier is trying to get his life back together. He needed to go to work that night because he's trying to get back on track, okay? So it's not unusual to me that someone who really needs that job wouldn't want to miss work because of this issue or whatever was said. He truly feared for his life in those moments. And he told us as such. And he's justified in using that weapon. Because not only did he believe that a commission of a forcible felony was about to be committed against him, because DeMarco had a knife, but he also was justified because he thought that knife or that gun or whatever was in the bag could have been used to cause death or seriously bodily injury. And that's not unreasonable because, again, there was a deadly weapon in the backpack of the decedent. And again, none of us actually know what happened in those 30 minutes because we can't see fully what's going on behind that column, and we don't hear what's actually happening. This is another charge that the judge will go over with you. It's grave suspicion. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are simply not enough. It's not sufficient to authorize a conviction of Xavier. That means maybe, or probably, or most likely. Not enough. That is not enough for the state to meet their burden in this case. And if you have reasons to doubt, and you should, then that's a question. And that's an unsettled mind, and that means you're unwavering. And if that is the case, then by law, you have to acquit Xavier. Again, judge will talk on this when he gives the jury charge, but essentially, Xavier, like I just said, was owning up to his past. Cannot use that against him other than for this limited purpose of the case here today. So there's one slide that I left out, and it's about sympathy, and I believe it's in our draft jury charges. You have to decide this case on the facts. I talked to you on Tuesday about listening to the facts and then taking the law the judge gives you to seek truth, right? And that is what your job is. Sympathy for DeMarco or sympathy for Xavier has to be left outside of the jury room. You have to decide this case based on what the state has presented, and you have to decide if what they presented is enough to get them to the highest burden in all the land, which is beyond a reasonable doubt. Every question in your mind that is unanswered is a doubt, a reasonable doubt. The state has not proved this case, and you must acquit because they have not met that burden. Now, I'm about to sit down. And I'm scared because I know I am probably forgetting to tell y'all about 15 different things. And so when I go sit down over there, I'm gonna think of everything that I wanted to tell y'all that I forgot. And this is my only chance to speak to y'all. The state, because they have the burden, they get to go again. And so they're gonna come up here and tell you why I'm wrong. But I want you to remember that the law is that they have the burden and they have to prove each and every element of this crime beyond a reasonable doubt. Not me, not Xavier. So when you're in the jury room deliberating, I want you to remember the government did not even bother to figure out the why in this case. They didn't bother to fully investigate, even though someone lost their life here. And it is truly tragic that DeMarco passed away. No one is disputing that. The district attorney's office got this case and they indicted it without clearing up all of this, without figuring out the why. They indicted the case, and Xavier has been coming back and forth to court over the course of the year. And he has maintained his innocence from day one, that this was about self-defense. And I just want to point out, to actually take a case to trial, especially in Fulton County, someone has to be sure of themselves, right? It's not easy to leave your life in the hands of 12 strangers. You don't have to like Xavier. You don't have to like me to know that he's not guilty of murder. So, like I said, I'm gonna sit down and remember what I forgot to tell y'all. But I want you to remember that when you get back there, if you have any questions at the time, you must acquit. So I'm asking you to find Xavier not guilty. Thank you.
Thank you, Ms. Wood. Mr. Rao, are you doing part 2 also? Mr. Abadi, how long do you forecast part 2 lasting? You have, just so you know, you've got an hour and 10,
Less than that.
but an hour and 9 is less than that. So is 5 minutes.
I would say 45 minutes.
45 minutes? Okay, I turn to the jury. You won't get the case today regardless of whether we have Mr. Abate go now or first thing in the morning, because I still have to charge you and we won't fit both those things in. So you're coming back tomorrow. So don't let your thinking be, wait, if we just push a little further, we'll finish tonight. You're not going to finish tonight. I'll be seeing you. You'll be seeing me tomorrow morning at the time of your choosing. Knowing that, I want you to confer, and we'll do it right here, you don't have to go to the jury room, about whether you want to be here till about 6 and have the closings finish. Oh, I've already seen a couple heads shake no, and it really don't take a lot. So what we're going to do is start up in the morning. I'd love to say 9, but I'm wondering if I need to say like 6, and then you'll be here by 9. Why don't you all tell me when you think you can be here tomorrow morning? And I 90% of you are here on time, but we can't start until all 14 of you are here. So what time would you like to start tomorrow morning?
You told me.
Can someone pick her up? Maybe that would work.
She has been here early when I was. 9:30.
Okay, 9:30 it is. Because I'm letting you pick, you need to be on time. If I picked, you say, oh, Judge, you picked a time I didn't like, but you all have picked 9:30. Everyone else is going to be here at 9:25 or earlier, ready to go. When you get here, we'll file out here. Mr. Abate will be ready with the rebuttal part of the state's closing. I'll be ready with the jury charge to give you, and then you'll begin your deliberations. Even though the evidence is closed, tonight would be a bad night to talk with people about the case. You still haven't heard the law. You've heard the lawyers talk about it, but the actual law, which is not going to be all that different, will come from me in the morning. That's what you will apply to the facts as you find them to be. So tonight is another night to bury yourself in television or wine or whatever you do in the evenings, and then come back here ready to go. I'm here at 9:30, so I hope I see you all at 9:30. Any logistical questions from any of you? Hearing none. Yes, sir.
I need like an email so I can send my boss.
Okay.
Yes, that'd be great.
When you say an email, I can, when I'm done, send an email. I'd need an email address so you could get, oh, I've got an email address because that's how we got you. It would be an email explaining that jury duty has extended an additional day. Okay. All I can do is send it to you. I don't know who your boss is. You'll send it from me to you to this mean boss who doesn't trust you. Okay, remind me where you work.
State Farm.
Okay, State Farm. All right, shouldn't be a problem. Yes, ma'am. Does Clear need an email also? Okay.
I would like a letter.
So you will get a letter. When we wrap up tomorrow, I think we'll be done tomorrow. That's your commitment is through tomorrow. When you're done with your deliberations and you decide what you decide, everyone, even if you don't need one, you get a nice letter on fancy paper with the court's letterhead on it. And that is what you'll be able to present to anyone who's been saying, where the heck have you been all week? But if you need something to bridge from today to tomorrow, that's the email I'll be sending. What juror number are you? I want to make sure I send it to the right person. 3. You're Mr. Is it pronounced Bayona?
Yeah.
Got it. Well, regardless of how we pronounce it, I've got you. So number 3. Did you also want an email, or you're good if you get that nice letter?
Both.
Both. All right. You will not get the letter today. And you are juror 41, Ms. Washington? All right. I will send a similar email to you so you can send it to Clear. Anyone else? Everyone else is good? You're managing your spouse or supervisor or pets? Deputy Gordon would like one. Yeah. Nice try. Okay. Thank you, everyone. We'll see you at 9:30 tomorrow.
I guess. I appreciate it. I forgot. The best.
Oh, it's empty? Dang.
I forgot.
Well, Deidre's here tomorrow. She can help with that. Okay. Mr. Abadi, anything before we break for today? Ms. Wood?
No, Judge.
You guys have fresh set of clothes for, he's breaking down your clothes closet, for Mr. Mosley for tomorrow?
I think so.
Okay.
I'll make sure.
Good. Then we'll see everyone. Please be here 9:15-ish, in particular the state, so they're set up. Mr. Abadi, if you're gonna use your mega board or whatever it's called, just make sure you're here early enough that that's set up.
Yes, sir, I'm making a plan video, see testimony of the defendant.
Okay. Well, I'll see everyone in the morning. I will email the final charge, that incorporates, justification, excessive force, the thing about words not being enough, but also, well, the things you requested as well. So look that over. In fact, I forgot about that. Why don't we meet at 9? At least one prosecutor be here at 9. Mr. Mosley, you'll be here. We'll get you out here. We need a defense attorney here at 9 so that we can have a final discussion about the jury charge. I do not want to make the jurors wait on that. So 9 a.m., everyone. Thank you. Thank you, Ms. Rivers.